Today is April 6, 2023. My name is Beatrice Cazzo, Special Magistrate for the City of North Miami. The purpose of this hearing is to determine if a code violation exists at your property, as observed and cited by a code enforcement officer of the city. If the city is not able to prove its case, then I will dismiss the case and you may leave. These proceedings are being recorded, therefore all persons who are speaking should do so one at a time to ensure that all testimony is clearly audible on the recording device. If English is not your primary language, then we have a translator who will assist you during the proceeding. When your case is called, the property owner, agent for the property owner, and any witness that you may have should raise your hand when your case is called. When asked, please speak directly and say aloud your name, your business address, and your relationship to the property. If you are not the property owner or an attorney representing a property owner, then you must present a notarized power of attorney affidavit in order for your testimony to be taken on behalf of the property owner. For new cases, you will be asked for the record if you are aware of and understand the violation that is being heard today. And do you understand what is required to resolve the violation? Please answer. The city will present its case first, and then the violator and or property owner will be given the opportunity to testify on behalf, to bring forward witnesses, to present evidence and photographs, and to cross-examine the city's witnesses. Following the case presentation, I will issue a finding of fact on the case. If I find that a violation of city codes exists or existed at your property, then depending on the case type, I will set an abatement date for the violation to be resolved. Or for repeat violation, I will impose a daily fine amount. For new non-repeat cases, my order will include an abatement date by which you must resolve the violation, and a daily fine amount that I may impose at a future hearing date should the violation not be resolved by the abatement date. If I find sufficient cause to postpone enforcement action at this time, I will take this case proceedings to another hearing date in the future. If you do not agree with my finding of fact and or ruling, then the property owner may appeal the administrative order on the case to the city. The appeal must be filed 30 days. Execution of the administrative order to be appealed. In accordance with Florida statute, if a person decides to appeal any decision made by a special magistrate with respect to any matter considered illegal, then the person will need a verbatim record of the proceeding. This record includes the testimony and evidence upon which the appeal is to be based. The cost of obtaining the verbatim record shall be the sole responsibility of the appellant, and it is recommended that persons who plan to appeal their case should provide their own proceeding. Pursuant to city codes, if the city of North Miami prevails in prosecuting a case before the special magistrate, then the city will be entitled to recover all costs incurred in prosecuting the case. The current cost assessment amount is $100. Once the city reports an order that imposes a fine and authorizes a lien against the property, then the city will charge additional administrative to record in the lien. Madam Clerk, any administrative item?
We do. Good morning. Can you guys hear me?
Good morning. We can hear you.
I'm going to proceed first with the order of today's hearing, and then after that, we'll proceed with I believe the Pledge of Allegiance, and then we'll do the deletions. And thank you for participating in today's special magistrate hearing. I'll review the process by which today's hearing will be conducted. Make sure your device is muted at all times unless you are giving testimony on the case. If you are using two devices to participate in today's hearing, be sure your audio is only enabled on one device. When your case is called, if you are signed into Zoom, you will receive notification giving you access to audio and video so that you may give your testimony. If you are physically here in person and wish to give testimony, you must sign in with the court clerk and await a text message indicating your case is ready to be heard. Upon receiving that message, you should immediately come to the code compliance office to be provided access to a computer. If you would like to speak on behalf of a case, once the case is called, you should click on the raise hand button to be acknowledged. Before giving testimony on your case, please state your name, property address, and relationship to the property. If you wish to have an interpreter assist you during your case, please indicate that when your case is called. And those are the instructions for today, Magistrate.
Great. Are we ready to call our first case?
I'm going to go ahead and do the pledge first, Magistrate, and then we'll swear in the staff, and then we.
All right. Where is everyone?
Just a moment when I grab the flag. Yeah, if all city staff can enable their their video, please. I think you might be on mute.
Yeah, I can't hear anything.
Yeah, try it again. It's a little staticky. Try to unplug the headset and maybe you put it back in?
Yes. Still nothing. We still can't hear anything.
Can we just have her dial in, guys? No.
No.
Maybe your volume's down. Will we check the volume? All right.
Well,
Can we just have her dial in, please? In the meantime, maybe clerk, should we just go ahead and have do the oath for the city staff? Is that okay, Magistrate? You're on mute.
I'm sorry. I said yes, absolutely.
Okay. All right. While they're working on that, let's do the oath.
The clerk is actually with her.
Oh.
Yeah, I'm gonna tell her to go back and to do the swearing in. 1 second.
All right.
My apologies.
Stop sharing so we can have everyone on screen.
Yes,
Yes, we can hear you.
You guys can hear me?
Yes.
Okay, so we'll proceed with the pledge of allegiance.
So I want to headphones, right?
Yeah.
Okay. Okay, we're ready. I pledge allegiance to the flag of the United States of America.
I think we probably need to. Can we wait? Just wait for the staff to get back to their computers.
Oh, okay. I'm sorry.
Yeah. Sorry.
No
Sure
problem.
what happened. Okay. All right. Okay. I think we're okay now.
Okay. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
If I can have all staff to the oath, please.
Do you swear or affirm that the testimony you are about to give in these proceedings will be the truth, the whole truth, and nothing but the truth? If so, say aloud, I do.
I do.
Thank you.
Translators?
Do you solemnly swear or affirm that the translations which you are about to give in these proceedings will be accurate and correct to the best of your knowledge, skill, and ability? Say, I do.
I do.
Thank you.
Okay, thank you. Madam Clerk, if you can call the first case.
Well, as far as for the deletions from today's agenda, we'll proceed with item number 1, 1180 Northeast LLC, CFAW 20.
Shanna, can you mute yourself, please? Shanna Sanders, can you please mute yourself? Go ahead. Sorry, Peggy.
The deletions from today's agendas are item number 1 and item number 5, which is 1180 Northeast LLC, case number CEFAW 20220071. This case was removed from today's agenda. Item number 5, case number CEZPU 2022001117. It was removed from today's agenda. Item number 30, ND Credulous, case number CEMHS 2022000419. It was removed from today's agenda. Item number 37, CoinCo Invest Co. Inc., case number CEMHS 2022000433. Was removed from today's agenda. And item number 60 through 62, Penniless Felix, case number CEIVY 2022000102, complied. Item number 61, case number CEODS 2022000136, complied. And item number 62, case number CERCV 2022000235. This case we'll proceed with today is item number 34. We have Benjamin Jacoby. And the case number is BUNSF 20220001. This case was previously found guilty with an abatement date of July 8, 2022. Fine was set at $500 plus $100 cost assessment. And Mayor Jin will be presenting the case today. And magistrate, the 3 abatement dates that will be following for today's hearing are May 18th, 2023, June 15th, 2023, and July 20th, 2023.
You said May 18th,
Yes.
June 15th?
Yes, and July 20th.
Got it.
Mr. Jacoby, if you're there, please enable your audio and video to be acknowledged in the meeting. Benjamin Jacoby, are you there?
Good. Yes, I'm here.
Good morning, Ben.
Good morning. How are you?
Ben, how are you?
So, I've got my property management person here. Can he tell us this, give you guys the status?
Sure.
Hello, Your Honor.
Morning.
Good morning.
Give me 1 second. Sir, can you please raise your right hand? Do you solemnly swear or affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth? So help you God. Please say I do.
I do.
Okay, so what's the status?
The status is we have a permit that's approved. We had an inspection, which the work was done completely already. There's no life safety issue. All the work's completed. Our only issue is the engineer is so backed up, he had to do his own report saying that everything was done structurally correctly in order for the permit to be finalized. So he's still working on that. All these engineers that I deal with, they're so backed up with work. They say it's coming, and we're at their mercy. So that's really where we're at. I just need a little more time, 30 days, if you don't mind.
Okay. Mr. Jean?
Good morning, Madam Magistrate. Good morning, everyone. I visited the property yesterday, and it's not in terms of my perspective, it's not safe. There's still cracks where the overhead soffit meets the main building. Also, we still have, although the permit was issued, but the engineer that provided the documents, his license was suspended. So, and I expressed that to Mr. Jacoby last regarding to have another engineer to provide.
We hired somebody else.
Okay, but I don't have any information to update.
And Mr. Jacob said about the delay and those issues, and especially we had to leave the one we had, so we had to do a new one. So that didn't help either.
So with that, new documents would need to be presented to me. With this new engineer, basically a change of engineer would need to happen. But my next course of action would be unsafe. If
you have pictures of what you're saying is unsafe, because I just walked in here, I didn't see anything safe.
Okay, look on when you going south. Well, when you go south from the soffit, look at that crack that's running underneath along the vertical crack that's running between the vertical crack right there. That crack is still present. So there's something happening with that overhead soffit, and this is my concern. Along with there's some the stability, to have your engineer verify the stability of the drive aisle that's going into the building as well. Okay, so that whole wooden structure. So
okay, no problem. I didn't recognize what you just said until you showed it to me. But the work that I was referring to is the one in the underneath the overpass, where the trusses were replaced, or the beams were replaced, holding that up. We have pictures of all the work that was done with new bolts and new hangers and everything.
That's not weight bearing. There's nothing underneath that. That's all.
So the engineer has to provide me that in detail to convince me that it's safe and stable.
Understood.
But as of yesterday, it's still not complied with. So, my next course of action is unsafe structures.
All right. How long?
30 days, ma'am.
30 days. Okay. Officer Jean, 30 days.
You can give him 30, and I'm still going to proceed it with unsafe, to make sure it gets done, because it's been dragging for a while.
Magistrate, just for your consideration, 30 days won't repair the situation. I guess he's asking for 30 days to go into a relationship with the new engineer. Is that just for clarification? Because the case has been sitting since, it's been a year now since we opened the case. And the city would ask you, Magistrate, that you would consider running the fine at this point to hold the property owner accountable to moving forward with what the city is suggesting is an unsafe circumstance, specifically as it is on the exterior of the property and potentially it overhangs the sidewalk area. It could potentially be a hazard to any pedestrian that's walking past the building. So naturally, as you're aware, Magistrate, the city does, work with the property owner to mitigate once the fines have been running. But I think that we do want to hold them accountable for your consideration.
Okay, understood.
Who spoke? I'm sorry. Someone said, was it you, Officer Jean?
No, that was the property owner.
Mr. Jacoby there. And Mr. Jacoby, your engineer has to address that initial letter that was sent. Make sure they go through those items of concern.
Yeah, we delivered that to them, and
he's going to send a new letter.
Or you're going to do a new letter.
Well, I have them address what's the original
Right, I got it. That's what I thought.
Okay. And it needs to be, it's not just a letter saying that everything's okay. Provide proof, photographic evidence showing that it's stable. And if he needs to provide calcs, whatever he needs to convince the city that it's stable.
Okay, we understand.
Okay.
Thank you.
Thank you.
Thank you very much.
All right, thank you.
Magistrate, are we just tabling the case for 30 days?
I'm sorry.
What is the final outcome for the case?
Okay, let's give him 30 days. Counselor, you understand that the city wants me to abate the daily fine. I will address that at our next hearing, but in the meantime, you need to get to the building official document from your new engineer, but understanding that he's going to proceed because he believes that the building has, and for your safety and everyone else's, but I'm giving you the space because I do understand that you just retained a new engineer, so I'm that time frame. But when we address it in 30 days, we will have to address it. All right.
Okay.
Love you.
Thank you, Your Honor.
Thank you, Madam Magistrate.
The next item is item number 7 through 13. It is 1515 Coral Towers Sport. Case number for item number 7, CEMHS 2022-00402. Item number 8, case number CEMHS 2022-0040404. Item number 9, case number CEMHS 2022-00406. Item number 10, case number CEMHS 2022-00407. Item number 11, case number CEMHS 2022-00408. Item number 12, case number CEMHS 2022-00409. And item number 13, case number CEMHS 2022-00410. And the officer is Christopher Colson.
I have a Mario Nunez here on behalf of this property. Mr. Nunez, if you would enable your audio and video.
Is it working? No.
Looks like you're using 2 devices, so you're going to need to mute one.
I did.
And I need you to enable your video on the other.
It seems like it's on and just coming on because my only option is to stop video right now. Integrated webcam, virtual. Let me just leave from the other device. Start there. I guess I'll start it on this one since that one's not working.
Please raise your right hand, sir. We can see you. Do you solemnly swear or affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth, so help you God? Please say I do.
I do.
Can you please tell us your full name and relationship to the property?
My name is Mario Nunez. I'm the president of the association.
Thank you, sir. Good morning, Officer Colson.
Good morning. We ready to proceed?
Yes.
Okay. Good morning. This is a new case. My name is Christopher Colson, Code Compliance Officer, City of North Miami. We're here in the case of CEMHS 2022-00402. This is in relationships to screens on the property. Original violation was open on 5/4/2022. Did a reinspection on 6/16/2022. Violation remained at that time. As of final reinspection of 3/16/2023, the violation still remains. The screens are still damaged or missing. You want me to keep that? Would take care of that case. You want to pause and you want me to just give all the cases at one time, back to back?
Unless Mr. Nunez.
Yes.
Okay, what's going on with the, I'm assuming that there's a lot more work going on in the building. That's the reason why I wanted to hear everything. But Officer Colson, if you want, after each case, you want to give him an opportunity to respond, we can do it that way as well. So,
Okay.
Mr. Nunez, why don't you tell us what you're seeing on the screen and what's going on with the screens, the missing one, the tore up ones, and going on with that.
I just got these documents this morning, but I did see those screens. I was not aware that there was something sent to us prior. I do not live in the property. I actually just drove down from Port St. Lucie, where I currently live, and I thought I had to be present, like physically. But I will. I spoke to Code Enforcement, Mr. Colson, sorry, and I will be writing letters to the owners to make sure that they replace the screens that may need to be replaced and repair the ones that need to be repaired.
All right. Based on the everybody testimony of the Code Enforcement Officer, I do find the violation does exist, hereby find in favor of the city. Intern adjudication, and the screen. Gonna take a while. I'm gonna do days. That would bring me to June 15th as your abatement date. Giving you some time. I know there are 4 things going on with that building, so I'm going to try to see if I can have all the cases run together. 6/15 is your abatement date. Okay?
Okay.
What's the fine amount?
What did you say, Madam Clerk?
What is the fine amount?
For the window screens, 200.
Is it possible that we not get a fine and that we work to repair the issues? Because like I said, I became aware of this last week. I didn't have the physical documents, and I've come straight down to take care of it as soon as possible. And I will make sure that the owners take care of each one of because each unit is individually owned. It's not like it's a condo. So I have to reach out to owners that may be in California. I mean, literally, I think there's one somewhere in Europe, in Brazil, in Barbados.
Mr. Colson, the abatement date, I gave you 60 days, is to make sure that, they understand that they need to get the job done as soon as possible. When you come back, if I see that there are
I lost you guys.
Progress being made, and I can ask Officer Colson, when did you open this case?
The case was open on 5/4/2022. I did speak with Mr. Nunez this morning. He came into the office. It's the first time I spoke with him or anybody from the property was this morning. And I explained some things to him. So
this matter has been open for over almost a year now.
yes.
This is not new. All right, you can proceed to the next case.
Next case is also a new case, CEMHS 2022-00404. This is one of the units that has a broken window. And the violation was found on 5/4/2022, did a reinspection on 6/17/2022. That violation remained. As a final reinspection on 3/16/2023, the violation of the broken window still remains. It's actually worse than it was before.
I'm sorry.
This is a squatter situation where the owner of the unit passed away. There's an estate, and the owner has her daughter living there without condo approval. We've asked them to make the corrections, but they don't even allow us in the unit. So we can't make the repair for them. I asked the Inspector Carlson to see about transferring that to the owner, since we can't make changes to individual units.
Magistrate, if I may jump in here, the city does provide for a squatter provision in our code. So if as the, condo president or the association, we can work with you to open up a squatter case. There is a process for that. Magistrate, if you want to, I don't know if you want to table this matter, and we'll work with him, Mr. Nunez, on the squatter situation.
Okay, let's table this one as well and bring it back in 60 days.
Ready for the next one, Your Honor?
Correct.
Next case, new case CEMHS 2022-00406. This one deals with a business tax receipt for the property as a whole. The violation was found 5/4/2022. 6/17/2022 was a reinspection. The violation still remains. As of final reinspection, 3/16/2023, violation still remains. Still has no business tax receipt on file.
How are we with that process?
I'm sorry, I didn't hear that.
Where are we with the process?
Like I said, I just received all these documents today. I went to the city to apply for the certificate of use, and I don't know which screen I'm looking at here. Certificate of use, and they told me that I need to get that before I can do the business tax. But I will be submitting this today. They've asked for certain documents that I will need to get to them, but I will be submitting this today.
Okay. All right. I'll give you a break on that. I'll table it for 60 days as well.
Your Honor, this is a BTR, and the next case after this, the 2022-00407, that's the certificate of use. You want to table them together?
Yes.
Okay. So we'll go down to the next case, which would be CEMHS 2022-00408. This is for the parking lot. The violation was open on 5/4/2022. 6/17 was a reinspection and violation still remain. As of final reinspection on 3/16, the violation still remains for the parking lot, still in disrepair. No permits or anything on file for the parking lot to be repaired yet.
And have any photographs?
What number was that? We heard a BTR case.
We have the BTR case. Then she tied the CU case would have been after that, so we went to 0048 after that.
Okay.
11.
All right.
This case was also open on 5/4, correct?
Yes, 5/4.
Okay. And no permit has been.
No permit.
Yeah.
Again, the same with all the others. I just got the documents in my hand today. I spoke to Inspector Colson, and he suggested, as far as the outside part, that I contact Public Works in reference to the damage caused by FPL. They've asked me to call FPL, so I will be speaking to them today. As far as the interior, I requested 3 companies to give us some quotes to see how soon we can get this started, request a permit, and get our parking lot in proper order.
Okay, I'll give you time, the 60 days, but at this point, because of the time period, this is a case that was open almost a year ago.
Sorry, I don't live on the property, and I don't know how to update my address, so maybe something comes to me directly, because I did not get the copy until I got this one, that someone happened to see it posted on our display board. And Yes. So I'm sorry that I didn't know that this was been open since last year. I would have gotten on it a lot sooner, and I apologize for that. And part of the issue is that I live so far away. So we do have my address. I'm not sure what happened. Yeah. Because I got this from the physical copies that were dropped off at the building, so I'm not sure what happened there. Why?
Based on the evidence presented, I find that the violation does exist. I find in favor of the city entering into the case. You have 60 days by which to resolve the violation. If the violation is the abatement date,
Magistrate, I think your audio is kind of going in and out. Not sure.
Yes. It is? Okay. I'm not sure why. Okay, let me restate my ruling. I apologize. I do find that the violation does exist based on the testimony of the code enforcement officer. I find it in favor of the city in for an adjudication. Owners have 60 days by which to resolve the violation. If the violation is not resolved by the abatement date, there will be a daily fine amount of $500. Can you guys hear me better now?
Yes.
Okay. And just to confirm, Mr. Nunes, the abatement date is June 15th.
Yes.
Correct.
Thank you.
Okay, new case. CEMHS 2022-00409. This is a extermination case where it should provide us with a extermination report saying they get the property exterminated. On 5/4/2022, the violation was found. 6/17/2022, violation still remains on a reinspection. As of final reinspection on 3/16/2023, violation still remains. No report has been submitted.
Our handyman, our maintenance person, he actually exterminates and himself purchased the materials online through Amazon, and he does the inspection. So I was asked to provide a receipt, and I will be providing receipt of that that we're buying the chemicals necessary for this.
Or you can just provide the city with, a statement on official letterhead that you guys have sprayed, and that would also be adequate.
Okay.
All right. Can we do that within the 30 days?
Yes, of course.
All right. So your abatement date, I'll just table it. But for you to provide the city a letter for explaining and letting them know that property has been exterminated.
Okay.
Within 30 days.
Okay, last one of the new case. CEMHS 2022-00410. This is for contact information that needs to be posted on the property, visible, so we can have emergency contacts or anything if something happens. The violation was found on 5/4/2022. As of 6/17/2022, reinspection violation still remains. As of final reinspection on 3/16/2023, violation still remains. No contact information posted.
Right. Mr. Nunez, you have a lot of violations that you need to handle. And again, this is one of the ones that I'm giving you 30 days. You've had a year, giving you 30 days to get it done. If this comes back, then I will have to adjudicate you and I will issue a daily fine. So these are easy fixes. Right?
Yeah, I'll post that.
Pride with the parking lot and the windows. But these are things that, that you didn't even have to come here today.
Yes, I'm sorry. There is something on there, but it doesn't specifically say my contact information should be at the bottom of our letterhead. But I was told that we need to put something that says specifically in case of emergency, where to reach me and where to reach our maintenance person. So that will be taken care of this morning.
All right, sir. Is that his last case?
Yes.
Okay, so good luck to you. We'll see you back here in 30 days if these two matters are not fixed, or in 60 days if you're able to solve them. Just reach out to Officer Coleman, and then he can take them off the calendar. Correct, Officer?
Yes.
Good luck to you.
How do I go about paying the fee on that first case? And Ms. Patterson, about the squatter case?
The fine has not yet been assessed. It's just been, there's just a ruling for now. So you were given a date by which you have to, you need to abate. If you fail to abate by that date, then the fine will be imposed. In terms of the other issue, if we have your contact information, please put it in the chat if Chris doesn't already have it, but we'll circle back with you after the hearing.
Okay, thank you so much.
No worries.
Next case.
Number 41, Gilbert Garcia and wife Maria. Case number CEODS 2022-00141, and the officer Gennaro Murillo.
I have Stephanie Garcia here on behalf of this property.
You said 41, right, Madam Clerk?
Yes.
Ms. Garcia, if you would enable your audio and video, please.
Okay. Okay.
Please raise your right hand, ma'am.
Yes.
You solemnly swear or affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth. So help you God. Please say I do.
Yes, I do.
Please state your full name and relationship to the property for the record.
Okay, Stephanie Garcia, and I am her daughter. For Maria Garcia. Gilbert Garcia has passed away, my father. Thank you. So I'm here now taking care of the property with my mother. My mother is here with me.
Good morning.
Good morning. Okay. I see the case has been open for a while, but I didn't realize that it was still open back in May when we got the first letter. We cleared up a lot of...
Ms. Garcia?
Yes. Yes.
I don't know anything about the case yet, so allow the
sorry.
officer to testify, and then I'll give you an opportunity.
Sorry about that. Sorry.
No problem. Officer Murillo?
Good morning. Officer Murillo from the City of Miami Code Compliance. On May 12th, I opened a case to the property address 1035 Northeast 145th Street. They were advised to remove all outdoor storage from the property. I had an inspection date on June 1st, 2022. There was no compliance. A notice to appear was posted on March 7, 2023. It was also mailed on March 8th. As I was final reinspection on March 16, 2023, there was no compliance.
Is this the back of the house or the front?
Well, there was items on the back, and there was also items put on the front after I did re-inspections.
But is this the back or the front?
Well, that's the front. This is the back when I did the re-inspection on March 16. She removed items from the back, but there's still stuff that needs to be removed.
I don't see a date. Oh, I can't see. It's there, but I can barely see it. These photographs were taken when?
Excuse me?
When were these photos taken?
Well, this one that you're seeing right now was on Thursday, March 16, 2023.
Okay, this is recent.
Yes.
All right. Okay. Ms. Garcia?
Yes.
Right. Do you understand the situation?
Yeah, I understand the situation. When we originally got the first letter, I wasn't here. It was my mom and my brother. Unfortunately, there's a little bit of a hoarding problem I am trying to correct. I removed a lot last year, but it wasn't enough. I didn't realize that the case was still open. I'm here full time now. I moved here with my family to help take care of my mom in the house, and I'm taking responsibility for everything, and I'm just trying to correct it. So I took out a lot of things. I spoke with him with the gentleman last week, and he explained exactly what I need to do. So I'm working on it. So if we could just get a little more time and I can get it corrected.
Okay. Case was opened in May 2022, correct?
Yes.
All right, Ms. Garcia, again, my condolences to you and your family. Based on your testimony, I think that now that you're here, maybe you can assist your mom. But I'm going to give you 30 days.
Oh, that would be great.
Okay, I'm going to give you 30 days. This is going on in here. And you understand the situation with your family and your elderly parents. I will give you some extra time. When we come back in 30 days, we'll see where you are. Hopefully, all the stuff that I do see in front of the house and the back, we're able to get rid of all of it.
Yeah, I made sure that I really went into detail with him so he could tell me exactly what I need to do to make sure this is corrected and it's done.
Okay, because it's unsightly. I'm sure your neighbors are not happy, right?
Yes. Yes.
So go ahead and get that taken care of. We'll see you back here in 30 days, or maybe not if it's taken care of. Just make sure that you reach out to Officer Murillo.
Okay, so if I clear it and it's where he told me it needs to be, I can call him. He can take pictures, and I don't have to be seen in 30 days.
That's correct.
Okay.
All right. Good luck to you.
Okay. Thank you so much.
Was I correct, Officer Murillo? If she calls you and you're able to visit the place, and if she's in compliance, you can take it off calendar, correct?
Yes.
And Ms. Garcia, 30 days brings you to May 18th.
Okay, perfect. That's more than enough time.
Wonderful.
I really appreciate it.
All right.
The next case I'll be calling is item number 46 and 47.
Mr. Nunez, you can leave, sir. Your case is done. He was asking.
He's still here?
Yeah, he was asking if we still needed to stick around.
Oh, in the chat.
Yes.
Okay.
I'm sorry, Madam Clerk. What number did you call?
46 and 47. La Plata Life Center. Case number for item number 46 is CEFOB 2022-00156. This case was previously found guilty with an abatement date of March 16, 2023. Fine was set at $500 plus $100 cost assessment. And as far as for item number 47, case number CEZCU 2022-006, it was also previously found guilty with an abatement date of March 16, 2023. Fine was set at $500 plus $100 cost assessment, and the officer is Shanna Sanders. Sir, please raise your right hand. You solemnly swear or affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth. So help you God. Please say I do.
I do.
All right, sir. Please state your full name and relationship to the property.
Name is Pastor Abraham Rivera. I'm the pastor and the president of the church, the property.
Thank you, sir. Officer Sanders.
Shanna Sanders, City of North Miami Co-Compliance Officer. The first case we hear will be CEFOB 2022-00158. This is the case for non-compliance. As already stated, it was originally heard, I was originally cited it March of 2022. It was already brought before the magistrate. They were giving a guilty finding and adjudication date as of my last reinspection being yesterday. Compliance has not been met. The business tax receipt has not been obtained at this time.
Pastor Rivera, where are we with the process?
Yes, Madam Magistrate. Yes, we have no business tax. It's not that we don't want to, it's we cannot because the building is under construction. If I can refer to, we have another case that was closed, which was the 40-year certification, which is what I promised you. I said, look, I'm going to pay for an architect to do this, even though it's not going to pass. And I did that. And I gave that to the city, and Inspector Jacobs has that. He says the building is safe. But again, I went again to do the business tax thing, and they asked for an inspection. And there's no way that a building under construction is going to pass inspection. I want to comply. I want to pay. I wish I could just pay for it and just, I don't want to be, controversy with the city, but there's no mechanism in place to get a business tax when something's under construction.
That makes sense. What's is it under full construction? You guys are not holding,
yes, ma'am.
Church
yes,
or anything like that, correct?
Yes, ma'am.
Okay, so if a building is under construction, how do they go about getting the business tax receipt? Mr. Jean, that's probably a question for you. Or certificate of use if they're under construction.
Well, with in terms of Pastor Rivera's case, the construction started, but it stopped, and the building's vacant. In terms of the, I can't tell you in terms of that would be a CP&D question in terms of the business tax receipt, how you would obtain it. But he's not, the building's not being used. I don't know if Ms. Patterson can add to that.
Yeah, Magistrate, and the officer, I'm sure, has a lot more background knowledge, but to what I understand, there was a construction project that started. It halted for quite some time. I believe that the pastor is holding service in another location. Under general circumstances, active construction, the city would be mindful of that and, not impose or require requests. But in this case, it's not an active construction site. The corporate licenses are active. Whether or not the pastor chooses to utilize the space for his services really is not, the concern of the city. It's just the licensures that are required. So, but for clarity, it's not an active construction site.
What is the intention of Pastor Rivera? What's the intention?
Madam Magistrate, when we bought the building, we had financing secured to renovate. And we got permits, we got engineering, we demolished the interior completely. And then when COVID hit, we had to close up church, our numbers went down, and they canceled our financing. So right now, I'm paying for the mortgage there, I'm paying for the upkeep. It's not an eyesore, but we're not using it. We're renting another property to actually run our business. And so right now, we're in the process of getting people back to church and giving again, so I can get approved for a loan, so I can go ahead and renew the permit and do it again. So I'm paying two different places and I'm not using it. And I'm not a lawyer, but I'm looking at the municipal code, and it says that I need to be engaging or operating in business. And we're not engaging, we're not using it, we're not operating any business. It's not an eyesore, we're keeping it up. It's pretty, it's lit up at night, but we're not using it. I
don't know if I hate to jump in. I don't know if it's possible, and maybe the attorney can chime in. What I would, maybe you might want to consider changing your principal address to whatever it is that you're renting on your corporate licensing. So this way, the city is kind of, you own the building, but if it's not engaged in active, it's not actively engaged in a business, and your principal address is not at that location, and you just own it and it's just sitting, I think that might put you in the clear, but I defer to the attorney's office to just double check that. But that would seem like maybe that would be some kind of a relief as it relates to these issues.
Definitely.
just to put in my 2 cents, good morning, Your Honor, Assistant City Attorney Tony Magnosh. Yes, he's not, if he's in the clear if he's not engaging in business and the property is vacant. I'm reading the language of the code right now, and it just says if you're operating a business. So he's correct. He does not need a BTR, but like what Ms. Patterson said, if going forward he changes what he's doing with that property, then it would be a different story.
Well, and so from the city's perspective, in terms of like engaging in business, right? We would take into account the fact that the doors are locked, the signs are gone, no one's there, right? And whether or not you're engaged as a church, Monday through Friday, the assumption is that the door is going to be closed. The city would have no way of knowing whether or not you're physically engaged in a business, other than the fact that you would consider changing, because what we base that off of is how you're engaged with the state of Florida. So in terms of how you're engaged with the state of Florida as it relates to your articles of corporation, your principal is here in the city at that building. So, that's how we would view engaged. If you're I would recommend that you would revise that location, that principal address, to wherever it is that you're operating currently. And that, I believe, would satisfy. You might want to double check with the finance office, our business tax, to verify with them that if that address is modified, would that satisfy the city's concern as it relates to your business tax?
I will do that.
And I wanted to add, it may be check also if you can set up a PO box. That way, it has a
outside of the city.
Yeah, outside the city.
And if I can chime in, as I directed the pastor as well, I've instructed him to possibly even remove the signs up there because it still has the signs on the building as well.
That's one thing I wanted to ask Crystal. In addition to going to that department and finding out and just changing his address, if he puts a sign that says that the property is vacant and not being utilized and there's no church going on, would that satisfy, I guess, codes?
Remember, so when you have a business, and again, we probably can dialogue about it offline a little bit, and this is why I'm kind of suggesting, but there's a series of licenses that the business is required to have, with the municipal license being the very last one. You've got your state, you've got your county, and then you've got your municipal licenses. Provided that business is registered with the state of Florida and it is an active business principal address in the city, right, then that business is required to have a business tax. So again, my recommendation is that it's not about your signs. It's about your license with the state, how you're registered with the state of Florida. That principal should be modified, that address. Go back and go to our finance office, have a conversation with them, confirm what I'm saying to you. But I'm pretty certain that will remediate this for you in the interim while you figure out, what you want to use the building for in the future.
I will do that. Thank you.
All right, so let's table it for 60 days and see what happens. Sir, just don't sit on it. Try to get this resolved so that we can close out these two cases while you're trying to figure out how to get the funding to get it. Good luck to you, sir.
Thank you. Thank you. Madam Magistrate, if I may add for the record, everybody at the city has just been so accommodating and so professional, and I just want to appreciate publicly. We don't want to be antagonistic. We want to work with the city, want to be an asset, and I just thank you for helping me through the process. Thank you all.
I'm sure they appreciate it because they've heard a lot of the opposite of the criticism.
Yeah. Mm-hmm. Yeah. Thank you all. Thank you so much.
Thank you. Take care.
We'll proceed with item number 51. Oxford Condo. Case number MGL 2022-00176. This case was previously found guilty with an abatement date of August 5th, 2022. Fine was set at $500 plus $100 cost assessment. The officer is Jonathan Lemestre. And we have Jerry Eduardo here.
Oh, that's the tenant, right?
Yes, that's the tenant.
Okay, sorry.
May I begin?
No, I'm not. I think you're letting somebody in. I don't see.
Yeah.
Okay.
Mr. Edward, are you there?
Yeah, I'm here.
Okay.
Carmen, please.
Okay.
Please raise your right hand, sir. You solemnly swear or affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth. So help you God. Please say I do.
I do.
Good morning, Mr. Edward. Please state your full name and relationship to the property.
Good morning, everyone. My name is Jerry Edward. My relationship with the property owner, she's my mother, Susie Edward. At the moment, she's not available. I will be here to speak on her behalf.
Okay, thank you, sir. Lemestre.
Yes. Good morning, everyone. Code Compliance Officer Jonathan Lemestre. As the clerk mentioned, this case has been open since January 19th, 2022. And as of the final reinspection date of March 20th, 2023, compliance hasn't been met. I have been in close contact with Mr. Edward, and he still tells me that the roof is still leaking water, that now there could be mold next to the vents in his mother's bedroom. The hallway ceiling is it looks like it's about to collapse. I don't know if Director, there it is. That's a ceiling in the hallway. That was of March 17, 2023. Water stains still show.
This is a rental property, or this is condominium?
Go ahead, Mr.
This is a property. My mother owns this property. It's a condominium.
But the condo association is responsible for the roof and.
Well, yes, for the roof, the damage of they're responsible for the up part of the roof, because we're in the third floor, and we have taken measures on previously on fixing the ceiling of the roof, the ceiling of the inside the property, because that part of the property is on our behalf, but the roof is continue and to leak, and it's continuing to damage the ceiling of the inside of the property, and we're not going to continue to spend money after money to restore this damage.
Magistrate, I don't know. Yeah, I was going to say, Jonathan, can you give the magistrate some backgrounds? The case is, we're just saying it's still leaking, but she doesn't recall the history. So if you can give more context.
No, absolutely. So the case, Mr. Edward's mother condo is on the third floor. It's a 3-story building. So what's above the condo is the roof. The roof is leaking water into Mr. Edward's condominium, which is causing the ceiling to collapse, to severely damaged. So we've been in contact with Michael Etienne, who is the condo president, I believe, Mr. Edward?
Yes, correct.
Yes. He did provide documentation back in February to Director Patterson and I that basically a patch was done on the roof, but regardless, the roof is still damaged. Water's still leaking even after the patch was done. And again, as of the final reinspection, water is still leaking into the unit from the roof.
I'm sorry to cut you off, Jonathan. I just been there this morning. At that exact picture that you're looking at right now, that everyone is looking at. I was not aware if Mr. Etienne has done any repairs, but this morning when I went up there, the roof still looked the exact same way as the photograph showing on the screen at the moment. It doesn't seem like any repairs has been done, and we're waiting for summer because we're pretty sure it's going to be a lot of rain and hurricane, and we don't want to wait around for the outcome of it, but I'm pretty sure there will be an outcome for sure.
Magistrate, I don't know if Mark is the building official. I know that
I feel like there's more that needs to be done. I mean, obviously, I can, I can do the fine, but these people are living in a very quite deplorable. I don't even know how it's habitable. It should be condemned. I'm seeing, things that look like mold, and I see a small child, and he's talking about his mom. He's probably elderly.
She's elderly.
There's more that needs to be done.
I apologize to cut you off.
So Mark, I know that the agent for the property reached out and said that I think that there was a time where they were looking to apply for a permit. There was a contractor that they were working with. And correct me if I'm wrong, I believe he subsequently came back and said that he no longer was representing the building. I don't know if you guys have a permit on file or what the status of any of that is.
Give me the number again of this case, the agenda number. Let me look it up real quick here.
Number 51. What do you want to MHBIO 2022-00176 Oxford Court Condo.
Let me hold on. Give me a moment, Madam Magistrate. Let me try to.
Mr. Edward, have you checked to see if the black stuff that we're seeing if it's mold? Did we get any mold testing done?
Yes, we have. Matter of fact, we had a company, a restoration company that came out that actually took out the water that was trapped between the roof and the ceiling. They actually came out and I don't know if Jonathan still has those photos.
If I may,
but I have sent him some photos previously.
If I may, I'm sorry. I received this from Mr. Etienne back in February, and he provided me an invoice of $5,000 that was paid to this company. Mark, I don't know if you looked at this, but
no, I haven't. I haven't looked at it.
So it looks like they did something. The owner of the unit is saying that nothing appears to have been done. I don't know if a patch job was adequate, but this is, magistrate, I mean, if it's, in terms of like ruling on the matter is one thing. I didn't know that the building official didn't have this document. We can collaborate on this and have him review it a little closer to see, or, perhaps even go out to the property. The only thing is, I don't know in terms of an unsafe structure, if that's something that can be done on a condo. Is it? Mark would have to speak.
It would need to be the building overall,
Yeah. So I'm gonna, and perhaps that's the roof. I don't know if anyone else in the building is impacted by the roof, issues, or if it's just the unit. I'm not sure, but magistrate, I mean, we're happy to take a closer look at the matter.
And I feel a $500 fine is low. But if that's what we have, then I'm ready to rule. I'm ready to run the
Yeah, may I add something into detail?
Mr. Edward?
Yes.
Yeah, so to add something.
Right. Apparently, we did had a restoration company that came out and did the job, restored, basically fixed our ceiling for us and removed some of the water and mold that we had trapped inside. Ever since that situation was taken care of, the same photos that Jonathan showed you, those were the outcome afterwards when we received more rain and, it started to have that same domino effect. So, honestly, I know this has been going on for a while, and this is the whole reason why I'm here, because I was living separately with my wife and my kids. We decided to move in to help my mom with the situation because she lives here on her own with 2-bedroom property. So, we're trying to help her as much as possible because we don't want to see her in this condition. And at the same time, it's kind of hurting us at the same time, putting our lives and our children's lives in this situation as well.
Understood.
Madam Manager, sorry to interrupt you. With this here, I don't see any recent roofing permit. The last one from 2011, actually it's issued, it's still not closed. So there's things kind of outstanding with this property. And also, if there were any improvements within the unit itself, they would need permits, any drywall replacement, any repair work would need permits for that individual unit as well. So we have some kind of issues there already.
Okay, well, I can only roll on what's in front of me. Based on the testimony of the officer and the tenant, I find that the violation still exists. The $500 daily fine is hereby ratified and plus cost. Mr. Edward, the only thing I can do right now is to ratify the daily fine of $500. Maybe that would get them to act. But you need to keep pushing and, go to the city, talk to Officer Lemestre and what else needs to be done. But, I can only do but so much.
No, trust me, Magistrate. I clearly understand, and I want to tell you and Jonathan and the city thank you because I understand and I know it's been a drag, and me and my family are taking more matters into taking care of the situation because it can only get worse if there's nothing being done about it. And we have LLC companies come out and check this out for us. I believe Jonathan has some of those information if you guys need it. But overall, we are going to keep pushing for sure.
All right, sir. Good luck to you.
Thank you.
I'll proceed with item number 52. We have Paul B. Roth, case number CEBTR 2022-00549. This person is here physically, and the officer is Shannon Fernandez.
Sorry, what number was it, Clark?
52.
52?
Mm-hmm.
Okay. Is someone assisting the resident with the computer?
Yes.
Okay.
Can you hear?
Nothing yet.
Nothing. No.
We can hear you.
We can hear you, sir. Good morning.
Please raise your right hand, sir.
Hello?
Yeah, raise your right hand.
Yeah, I hear you.
Please, do you need an interpreter?
Do you need an interpreter?
You're an interpreter?
Yes.
Do you need an interpreter?
Bonjour.
Yeah.
Au besoin interprète créole?
Pas de temps.
Can we have him adjust his mic, please? Can we have him adjust his mic?
We can take this off.
Okay.
I don't think he can hear through the headset, so we have him on the computer.
Yeah, we can hear.
Creole interpreter, can you ask him whether or not he needs an interpreter?
Pas besoin d'interprète créole, monsieur?
Pas de temps, non, pas qu'on
Please interpret for him, Creole interpreter.
Absolutely.
Please raise your right hand.
Levez mes doigts en l'air, s'il vous plaît.
Solemnly swear or affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth, so help you God. Please say I do.
Est-ce que vous jurez solennellement que tout ça, vous le dire là, tout témoignage vous le là, c'est la vérité, seulement vérité, rien d'autre que la vérité, et que bon Dieu vienne honnête? Dis oui, s'il vous plaît.
Yeah.
Yes.
Please state your full name and relationship to the property.
S'il vous plaît, dis-nous tout nom avec relation gain avec propriétaire.
Yeah, Paul Bill.
Put his hand down.
On met descendre, mais dis-nous tout nom et qui relation avec propriétaire.
Paul Bill what?
I didn't hear that.
Paul
Okay.
Bill. Paul P-A-L B-L-T-H.
Wonderful. Okay. And is he the owner?
Yes, I'm on.
Okay, thank you. Officer Sanders?
Shanna Sanders, City of North Miami Code Compliance Officer.
Hello?
C'est Shanna Sanders, officier compliance pour ville North Miami. Hein?
Yes.
This is a new case for building without permits.
Ça, c'est un nouveau dossier pour une construction faite sans permis.
This violation was originally cited and or brought to my attention. I would have to say February of 2022, whereas I had a conversation with the property owner as well as the tenant.
Et violation ça, elle était faite ou bien elle était arrivée et dans présence moi et le 22 février et côté que me parlé avec propriétaire là avec locataire tout.
I was allowed access into the property by the tenant, whereas I was shown different areas throughout the house, whereas construction appeared to be taking place.
Et propriétaire là t'es fini par bon moi accès à propriétaire côté que me t'ai remarqué plusieurs parties côté que gain construction qui a fait en dedans.
At the time of the inspection, I fully explained to the property owner that permits needed to be obtained. As of my last reinspection, applications have been submitted to the city, but they have been pending for some time.
Et donc, pendant temps inspection moi été expliqué à propriétaire que gagné permis et qu'il a bien besoin de permis pour travail ça qui a fait là. Et l'homme de fait dernière inspection moi gagné application qui a été soumettre dans bureau pour permis mais ça c'est un bagage qui a traîné pendant quelque temps.
I'm sure that application was submitted, I believe it was September or October of last year, but as of that date, the property owner, contractor, no one has come in to make any revisions to those applications that has already been denied.
Et donc, moi, ouais, que l'application était soumise soit septembre ou bien octobre année passée et jusqu'à date, et pas gagné un contracteur ou bien un monde et qui comme si représentait propriétaire qui venait pour capable de checker et application ça lui-même était refusée.
Non, quoi que can I speak?
Just 1 second. Let me make sure that the officer is still testifying.
Thank you.
That's pretty much my testimony. I'll let Mr. Paul explain what's the delay and what's going on with that application.
Bon, ça c'est témoignage par moi qu'on y a m'a quitté monsieur Paul expliquer qui problème qui gagne puis causer tout état ça pour application.
Okay, I've been to the them giving approval from from the permit. They approved my plan. Then I brought the plan to the city of Miami. They never called me. The last time, the Michonna, she has been in the house. She dropped the letter. When I opened the letter, then she said, I need to do that, do this. When I came to the city of Miami, they pull out, deny. They said they denied something. When they denied it, they give me the paper. Then I carry the paper to my architect. They working on it now. I don't know how long it take to finish the correction, but I'm waiting.
Okay. When did you go to the city and when did you pick up the paperwork?
Yes.
When?
No.
That was last month.
Great. So what the officer is saying is that you kind of dragging your feet. This case has been open since February of last year. So that's a long time. So you only have picked it up, last month. That's basically saying that, you guys are not doing what you need to do. The application was denied. That's your time to pick it up, bring it to your, your engineer or contractor and do the revision and bring it back.
Yes, ma'am. They working on it now.
Magistrate. Yeah, I would like an adjudication. As you already stated, they're dragging their feet. I originally noticed this violation in January, whereas we had a conversation. The application was submitted to the city. I'm showing here specifically May 31st of 2022. And as the property owner is stating, he just picked this up last month for revisions to be made. So, I would like to move forward with an adjudication. Maybe that'll, get a little movement going on with those necessary revisions.
Yes. All right, sir. Based on the evidence presented, I find that the violation does exist. I find in favor of the city enter an adjudication. I'm giving you 30 days by which to resolve this violation, which is basically resubmit they need to resubmit the revisions, correct?
That's correct.
Okay. 30 days, sir, because I feel that you've had ample opportunity to get this done. That would bring us to May 18th?
Yes.
Okay. May 18th, by which to resolve the violation. If the violation is not resolved by the abatement date, there will be a daily fine amount of $500.
OK, par rapport à tout témoignage que officier en bail, monsieur, moi, je vois que violation a existé. Donc, violation a existé et moi, pral bail et jugement par moi sur le dossier et côté que on a gagné 30 jours parce que le dossier a gagné pile temps ouvert, on gagne 30 jours pour capable résoudre lui. Seul ce qu'on gagne pour faire c'est soumettre révision qui fait yo. Et donc 30 jours maintenant jusqu'à 18 mai. Donc c'est date ça qui a gagné limite si toutefois violation ça ou bien problème là pas résoudre dans date ça ou a gagné une amende de $500 par jour qui a commencé à accumuler jusqu'à ce que ça résolve.
OK, moi j'ai une question tout.
I have a question.
OK, j'ai besoin de help. Premièrement, m'a dit que on va dire moi j'ai un premier architecte qui vient la caille moi un jour dimanche, monsieur Dario Herrero. Monsieur prend en même $2,500 pour te faire plan là pour moi. Il te charge $5,000. Il prend en même $2,500 as a deposit. Les moins regardé 15 jours bah monsieur, me vient écouter Michel Sanders. Pendant la liban moi donné monsieur. Les moins les monsieur me vient après il vient voyons il baillon dans les mairies il ont lettre pour bon moi côté que l'argent il prend même là $2,500 il fait qu'on est que c'est parce qu'il était venu garder job là il prend l'argent et là me consulter plusieurs architectes ils disent que yo pourquoi jamais qu'on bail comme ça pour monde vinn 40 monde pour prendre cob dans mel parce qu'il est venu mesurer un job c'est ça qui me prend petit temps on a un petit temps presque un mois pour me cacher dans l'autre architecte qu'on y a là qui vous fait plan moi besoin de la part magistrat pour dire qui côté malé pour faire suspendre la licence Mr. Dario Orio qui volait dans même $2,500 sans que il pas fait rien pour moi. Dario Orio.
All right. I would need some assistance with a matter that happened. I had a first architect. His name is
Dario Herrero.
His name is Dario Herrero. He came to my house on a Sunday to take a look at what needed to be done, and he took $2,500 from me for the plan. He was charging $5,000, but he took a $2,500 deposit. And 15 days went by. I haven't seen or heard from him. I went to Officer Shana, and she gave me Mr. Dario's contact information. And when I finally was able to get in contact with him, he sent me a letter with a lady named Mary. And in the letter, he explained that the $2,500 that he took from me was just for visiting the site and look at what the job was or what needed to be done. And after that, I started looking for other architects, and they told me that they've never heard something like that someone would take money from you just to, take a look at a job. And so the assistance I would need from you, magistrate, is to direct me to where I could go to, file a complaint and have that gentleman lose his license because he took the money from me, he stole my money, and told me that he was just for looking.
Then all information, if the magistrate wanted, I can give you all information from Dario Oreo. For
Mr. Reebok, that's not my job. That's not what I do. But I hear your complaint. I can ask Officer Sanders or Mr. Mary where he needs to go.
If we can, so that we can move forward with the magistrate hearing. Paul has my number. He can give me a call and we can discuss this, outside of the hearing.
Okay. Thank you very much.
Get contact with Officer Sanders. Okay, sir? Good luck to you. All right.
Magistrate, we're going to proceed with item number 6.
Is that 6?
Yes. We have 1330 Apartments LLC, case number CEMHS 2022-00391. This case was previously found guilty with an abatement date of March 16, 2023, fined with debt of $500 plus $100 cost assessment in the Office of General Offenders. And we have Andrea Andrada here on behalf of this case.
Ms. Andrada, if you can accept the invitation to join the meeting, please.
Oh,
I just need you to, there you go. Can you enable your big there?
Good morning, everyone.
Good morning.
You solemnly swear or affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth, so help you God. Please say I do.
I do.
Right, ma'am, please state your full name and relationship to the property. You can put your hand down.
I'm a registered agent of 3030 Northeast 127 Street.
Officer.
I'm sorry, Shanna Sanders, City of North Miami, co-compliance officer, hearing the case for 1330 Northeast 127th Street. This is a case that was already adjudicated. It would be coming back up for non-compliance. I am going to ask that this case be tabled if not granted an extension. I did have a conversation with Ms. Andrea prior to the meetings. I do see that she had sent me an email. An application has been submitted to the city as we requested in the last reinspection. I am showing that the application was submitted to the city on the day of the reinspection date, which was March 16th. So again, I am going to ask on behalf of, myself and the lit agent that this case be tabled and we give them the building department time to review her application for the repairs to the railings to be done.
All right. How long are we going to table this for?
I hate to do it, but the building department has been, going a little slow. So, I would comfortably say 60 days just to give enough wiggle room so that we don't, bring her back next month and have to request the same thing. So 60 days I would request.
All right. Let's reset 60 days. Thank you, ma'am.
Thank you.
The next items are item number 25 through 29. The officer Shannon Sanders. We have ND Fredulous, case number CEEXC 20. 015. Item number 25. Item number 26, case number CEFOB 2022-00349. Item number 27, case number CEGAB 2022-0002. Item number 28, CEMHE 2022-005. And item number 29, CEMHS 2022-00417. And sorry. Item number 31 as well, case number CEWWC 2022-0063. Item number 32, CEZCU 2022-00634. And item number 30 was removed from the agenda.
Is he present on the bringing?
Yes, he is.
Who do we have?
Andy Credless.
Andy, are you there? Andy, are you there? Okay.
Mr. Credulous, you have about half my calendar. If you're not responding, we're going to pass your case.
Are any of these cases going to be requested to be tabled, Shannon?
No, not at all.
Hello? So, Credulous, we can hear you. Please turn on your camera.
Oh.
Sir, please raise your hand.
Do you see?
I can see you. Good morning. Raise your right hand to be sworn in.
You solemnly swear or affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth. So help you God. Please say I do.
I do.
All right. Sir, please state your full name for the record and your relationship to the property.
Andy Credulous, I'm the owner.
All right. Officer Sanders?
The first case we'll be hearing, Shanna Sanders, I apologize. Shanna Sanders, City of North Miami Code Compliance Officer. The first case we'll be hearing is CEEXC 2022-00015 for the exterior conditions of the property. This case was originally cited on May 12th of 2022, whereas I was doing my annual housing inspection where several violations was identified. At the time of inspection, the property owner came outside of his unit. We had a conversation. He even walked the property with me. You know, he fully understood that the exterior of the property has dirt stains, mildew stains. The roof is deteriorating, is falling apart. He explained that he had a situation going on. He had a roofing company coming to see it.
I'm sorry. Do we have photographs?
Do I have photographs though?
No, not you, sir. Thank you. I'm asking the city.
Sorry.
There were photos uploaded. This is what the photos look like on the day of the inspection. I did an inspection yesterday, whereas it was in the same condition. Those photos weren't able to be uploaded, but again, they look to be in the same condition as they were on the initial day of inspection. As you're seeing here, cracks throughout the building, cracks throughout the ceiling, chipped paint, mildew stains. A lot of work needs to be done to this property. The property owner has explained he was submitting applications to the city. As of my last reinspection being yesterday, no applications have been submitted. And the roof, again, remains in that same condition.
Mr. Credulous, you've seen the photographs and you've heard testimony, Officer Sanders' testimony, sir. Is there anything you'd like to add? Have any questions?
It's a situation where it was an insurance claim since last year. Actually, the day that Ms. Sanders did her inspection yesterday, had the final inspection from the insurance to the to give me more money to rectify the roofing situation. But the interior, we had to go into interior to fix the situation, but it's actually patched up already. But
what I see, you need more than a patch-up job.
Yeah, but also Sanders says there's a couple of mildew stains that I need to paint over. But it's a lot going on with the trees. When the leaves falls on the exteriors, it kind of stains the eave sides of the roofs. So I am gonna paint, try to remove those mildews off the exterior.
Okay.
And repaint it.
All right. Trying to get to what it is that she wants to do.
I would like to move forward with an adjudication. As already stated, these cases have been open since May of 2022. You know, just as he stated, we, even as I inspected the property yesterday, had this exact same conversation about the mildew stains, about the trees, about him going to take care of it. But again, as of yesterday, I saw no movement from what I looked at it originally. So I like an adjudication.
Understood. Mr. Predelis, you indicated that you have a pending insurance claim.
Yes, Ms. Sanders was there with the insurance lady. I passed the final inspections, but I do yearly pressure washing every at least 2 times a year. So that's something that's going to be done as soon as possible, as I indicated to Ms. Sanders. I did it last year too. It's snow.
All right.
All the trees and mildew.
All right.
But the roof is fixed.
That the roof is fixed. I don't think the roof is for me.
Magistrate,
the facial boards and is he talking about the facial boards, or we talking about the roof? Is that you have several?
He has several cases. Yeah, this one is for the exterior.
I'm trying to take it one at a time, unless you want to do everything all at once, Officer Sanders, and have me rule individually. How do you want to do it?
I mean, we have a separate case for the actual roof that we can hear separately, if he wants to, or you want to hear them together. But it looked exactly like it looked in the pictures. Yesterday, as it did from the initial inspection. There was a woman who visited the property as we were having a conversation. I and her did not have a conversation at all, so I don't know who she was, but there was someone who came and was looking at the property. So I don't know what was inspected, what was passed, but it's and I hate to say it on record, but I'll be honest enough to say it on record. It's hard to believe, if it looked like how we look in the picture, that much work was done overnight. And if it was done without permits, and then that would be another violation. But I'm almost positive to say it looked just like it looked yesterday.
Okay, Mr. Predelis, based on the evidence presented, I find that the violation still exists. Even after a year into this case, been back in May 2022. And it's my understanding that the property looks exactly the same as it did almost a year ago. So I really do need you to get the work done. It's unsightly. And, I think that if you have tenants, I think they deserve better. So my ruling is I rule in favor of the city and turn adjudication. Sure, I'm giving you 60 days. That brings us to June 15th, 2023, by which to resolve the violation. If the violation is not resolved by the abatement date, so there will be a daily fine amount of $500.
Okay.
Moving on with the second case, just to file in order. That would be case CEFOB 2022-00349. That's in reference to the property not having their business tax receipt. Again, upon the initial inspection, on May 12th of 2022, inspected doing my annual housing inspection, walked the property with the property owner, fully explained what needed to be done. As of my last reinspection on yesterday, no business tax receipt has been obtained for that property.
Where are we in the process?
I'm not an attorney, but what is the criteria of a multi-unit to obtain a business tax? Does it goes by occupancy?
Has asked the question. I don't know if Officer Sanders.
Yeah, that was a question. If it's just me and my family, do I necessarily need a business tax?
You have a 6-unit apartment building, so yes, you would need a business tax receipt, as we spoke yesterday. Yes.
Okay.
So you've never had to take, you've never had one, Mr. Pettis?
Just me and my family.
When did you acquire the property?
2015.
You've never had to.
It was through my dad had the business property under his name.
Sir, are you okay? You're talking a little slow.
I'm talking low. I'm sorry. I'm talking low. It's under my dad's business tax.
Okay. So he had it, and now you need to make sure that it's transferred now.
Okay.
But I'm asking.
I'll update it.
Okay. All right. Please get it done. I'm giving you 60 days because I want all the cases to run together. But I do. You have a lot of things going on. Right. I'll hold off on the ruling on item number 26. You may proceed.
Okay. So that it coincides together, I'm going to ask it to be heard out of order. The certificate of use case CEZCU 2022-00634, because it kind of coincides with the business tax receipt. Again, on my initial inspection, May 12, 2022, walked the property along with the property owner, fully explained that a certificate of use needed to be obtained for the property. He said he fully understood. As of my last reinspection yesterday, whereas we walked the property together again, no certificate of use has been obtained.
All right. Mr. Federalist, I'm sure you have a lot more coming down the pipes for cases. You have a lot. What I'm going to do is give you a break. I'm going to give you 6 days. That's more than enough time to go ahead and get both the certificate of use and the business tax receipt. Now that you know that you need to have them, you said your father had them. Now, if you are the rightful owner of the property, you make sure that you're registered and pay whatever fine or fees needs to be paid, so that you can have the paperwork and right.
Yes, ma'am.
Next case.
Next case is case number 27, CEGAB 2022-00002. This is for a case for a business or commercial property not having the established in or required sanitation services that we usually, require. On my initial inspection, again, being May 12, 2022, I walked throughout the property doing my annual housing inspection. At the time of inspection, I observed or did not observe a garbage in the enclosure that was located. We had a conversation, I was inquiring as to where's their dumpster, how do they dispose of their garbage, things of that nature. He somewhat pointed into the direction of the neighboring property and said they use that one being the property to the east of them. As I instructed to the property owner, you need to have your own sanitation services for your individual property. As of my last reinspection being yesterday, had another conversation, still no sanitation services has been obtained. So I'll let, again, the property owner explain what's going on with his services, how they dispose of their trash and what's going on, just as a whole.
Yes, ma'am. We always had two, we had the recycle and the garbage. We always had that for our property. It's actually 2 garbage and 2 recyclables. That's all we needed. And
what the officer is saying, this is a, how many units are there, Officer Sanders?
It's a 6-unit apartment building. It's a small.
So this is a 6-unit apartment building, so you need to have proper sanitation, dumpsters, etc., so that everybody can use. I mean, you're not a rookie. You just told me that you acquired this property from your dad in 2015. So there's no way that you've been running this business. So you're kind of like nonchalant, lackadaisical, and that's the appearance. That's what I'm getting from you.
I have a question. I have a neighboring building, and they have 6 units too, and they have the same situation. They don't have a bin. They have they have the regular toters like I do.
Okay. I don't know what's going on with your neighbors. I don't know who your neighbors are. I'm going by what the officer is telling me about your particular building. So, in other words, are you saying each of your tenant have their own dumpster? Like they have 2 bins, like the regular and the recyclable? Is that what you're saying? So each apartment, each unit has the, what do you call them? The double dumpster?
The 96-gallon containers. And magistrate, no, there were no 96-gallon garbage nor recycle containers located at the property. The dumpster was clearly empty, and he pointed into the direction of the neighbor, stating he uses their garbage containers. He had nothing located at his property, not even the 96-gallon containers.
Is that correct, Mr. Perdolas?
We always had the toters in the garbage right there.
I'm sorry?
We have where the location where she sees it. We put the toters inside the enclosure. Is right in front of the enclosure.
I don't know what you're saying.
What's she saying? Where the bin is supposed to be? That's where the toters always been.
What are toters now?
The bin. I'm calling it something different.
The 96-gallon containers.
So you have 1 for the entire building for all 6 units?
No. In total, it's 4.
But magistrate,
four. Two recyclables and 2 garbage.
Just to make one thing clear, the city, once you are classified as a multifamily building, which is 4 units or more, you're required to have a dumpster. So you can't use a 96-gallon toter. So
I'm trying to understand what the tenants are doing with your garbage.
Well, Waste Pro took they didn't give me a reason why, but they took we had both. We always had the toters, the 96 gallons.
Magistrate, if I can, I'll try.
He's going to need to, he's going to need to establish service More than likely, there's some issue with the relationship between the multifamily and the vendor.
And that's what I was going to say. Yeah. And to give a little history, they were originally cited in 2018 for not having the proper services. They had an outstanding balance. So with them not having, having outstanding balance, Wage Pro picked up the waste ban. Since 2018, when I'm looking at the history, they picked it up and he hasn't had anything since. So from again, our conversation seems as though he's been dumping it in his neighbor's trash can since then. He's fully aware of even that violation, but that's something that was heard years ago and is already a lenient fine for the property.
All right. Based on the evidence presented, I find that the violation does exist. I also I find in favor of the city enter an adjudication. Owners have 30 days by which to resolve the violation. If the violation is not resolved by the abatement date, which will be May 18th. If it's not resolved by May 18th, sir, you're going to accumulate a daily fine amount of $350. Next case.
I'll jump back to case 28, whereas is CEMHE 2022-00035. This case is in reference to the property not having the proper extermination report and a notification provided to the city. Upon my initial inspection being May 12, 2022, did my annual housing inspection, whereas I walked the property with the property owner, fully explained what needed to be provided to the city, as well as yesterday fully explained what needed to be provided to the city. He clearly stated he does it himself. As I stated, just provide, just a notice. It could be a quick email stating what services you use, what products you use. As of yesterday, that email notice, nothing has been emailed to me about any type of extermination report or services that they provide for this building.
Sir?
I will provide a extermination report as soon as possible.
All right, I'm giving you 30 days. Okay.
Yes, ma'am.
All right.
Next case is number 29, CEMHS 2022-00417. This one is for the actual ceiling, if not roof, of the property that deals with, specifically the cracks and stuff throughout the roof. As of my initial inspection on May 12, 2022, I walked the property along with the property owner, observed several cracks, stains, what would appear to be leakage areas around the roof area. We had a conversation. He stated he had a roofing company or contract that was going on. He fully explained he was going through some type of mitigation or something going on with the roof. He had, some situations going on. As of that conversation, he was supposed to be getting things taken care of within 90 days. 90 days has come and gone. As of my inspection yesterday, the roof remained in the same condition. I see no permit submitted to the city. So I'll let the property owner explain what's going on with that. As he stated clearly, someone was there yesterday looking at it. So again, I will repeat, I'll let the property owner explain what's going on with the roof.
Yes, as I stated before, in terms of leakage, there's no more leakage. In terms of getting rid of the rest of the cracks and repainting, that's an ongoing thing. And I would try to do that as soon as possible, since the insurance made the fine. They're making the final payment, so I can get the contractors to complete the final steps of the job.
Okay. I do, based on the evidence presented, I find that the violation does exist. I find in favor of the city enter into giving you 60 days so that the can run together, except for the other two. For 60 days, and that will bring you to June 15th. If it's not resolved by the abatement date, sir, there will be a daily fine amount of $500.
And our last and final case is CEMHS 2022-00419. This case is for the property not having the proper identification placard which states, who's the emergency contact owner or who to contact in the case of emergencies. On my initial inspection being May 12, 2022, I had a conversation with the property owner while doing my annual housing inspection. Whereas we walked through the property, I fully explained what needed to be done, where it needed to be posted. As of yesterday, my reinspection, walked with the property owner again. No placard had been posted. So I would like to move forward with an adjudication for this one as well.
I thought you guys said that one was, I have the wrong notes. I thought it was dismissed. Never mind.
Oh, it was this one. Item number 30.
Yeah.
I received an email and for me to have this one removed.
Okay, so I am correct.
That's correct.
Okay.
Well, let me just clarify. Let me clarify. I believe that there was a faulty, there was some faulty documents, some faulty issues with the documents. So we had to remove it due to internal errors. So the clerk is saying she received an email to remove, but that's the context. So it was taken off the agenda. So we're going to need to reissue the violation in essence.
Okay. I take notes. All right. Next item.
Well, that was the last one for him that I had.
Okay. All right. Mr.
Wait, we got more?
Wait.
Oh, wait. Oh, no. We're saying more.
I still have, okay. I was about to say that you're taking off my entire calendar, Mr. Predalis, with violation.
For case 31, that one has been abated.
Okay.
I'll call that one into it. CEWWW 2022-00063. Upon my reinspection yesterday, I did observe that this one was for the doors around the storage room needed to be resealed, restuccoed, recracked. And I noticed that was indeed done. No permit was needed for that. Again, it just needed to be restuccoed. So that violation was abated and taken off the agenda.
Awesome. That item number 30.
That was 31.
32?
32, I think we ran it along with the business tax receipt case. Yeah, this was the certificate of use.
Okay, wonderful. Mr. Predalis, I'm just going to tell you, sir, get on it, right?
Yes,
get on it.
Sorry, Magistrate. For item number 26, 28, and 32, you did not assess a fine. You mentioned you were going to give for item number 26 to June 15th, item number 28 to May 18th, and item number 32 to June 15th, but there's no fine assessed.
Okay, you said for item number 26, I asked that to run item number 26 together with the certificate of use. Which item is that?
That is 32.
Okay, and how long did I give them?
June 15th.
June 15th. Okay, so I'm not entering in order. I'm giving him 60 days to get these matters resolved.
So we'll table these two.
Yes. What was the other item?
And item number 28, which is the one that the extermination report, you give them till May 18th.
Yes, I give him 30 days because all he has to do is send the information to Officer Sanders. And I feel that this is something that is so simple that he should be able to do. And, extermination report, get the extermination done and submit same to the officer. That shouldn't take you 60 days. Okay?
So item number 28 is tabled to May 18th.
I didn't hear you, Madam Clerk.
Just confirming, item number 28 is tabled to May 18th?
Yes, correct. That's it?
Yeah, that was it.
All right. Good luck to you, sir.
Thank you, Ms. Magistrate.
All right.
At this current time, the interpreters may dismiss. We only have one person in the queue. I did send Abel Rodriguez a chat letting him know he did not need to be present at the hearing because his case is not on the docket. And we'll proceed with the next case.
All right, before we proceed, I need to take a 10-minute reset.
All right, so we can come back at 11:40?
Yes, perfect.
Okay. All right, so I'm going to pause the recording. Again, Mr. Rodriguez, your case is not on today's docket, so you don't need to be here. If you're just observing, you're welcome to do so. We'll readjourn at 11:42.
Recording stopped.
Hi, Magistrate, are you back?
I'm here.
Okay.
Recording in progress.
Just for the record, Magistrate, we don't have anyone else here. On all the other items on the agenda are unrepresented. There are a couple items that we did need to table, so the clerk will read them into the record, and then we'll finish up whatever's left on the agenda.
All right, let's do that.
I'm still showing Abel Rodriguez here. Should we remove him?
No, from where he is. Oh, well, he's raising his hand. Mr. Rodriguez?
Hi, good morning, everyone.
Hi, what property address are you here on behalf of?
No, I'm representing myself. I had a outstanding permit that was recently approved.
But sir, what address? What's your address?
1060 Northwest 125th Street.
Okay, and we've already confirmed that that's not on the agenda for today?
That is correct. I sent him a direct message as well.
I had received a letter from the code enforcement officer to register for the webinar, for the Zoom today.
Okay, whoever the code enforcement officer is, please chat with Mr. Rodriguez in the chat, get his information, and make sure he's in contact with you directly. Reference his case. Mr. Rodriguez, I apologize that your case is not on today's agenda.
Okay, all right, thank you. I will contact the code enforcement officer.
Thank you.
All right, Madam Clerk.
Yes, Magistrate, the amendments for the remaining of agenda is item number 23 and 24. Case number CEFOB 2022-00370. Item number 24, CEZCU 2022-00282. This case was postponed. Item number 40. This case is in compliance. It's Iglis Evangeline. That's Carol Wynn. Case number SDNOV 2022-00626. This case is in compliance. And item number 54. Saint Julian Annelis, case number CETRA 2022-00104. This case was postponed. Item number 59, Stephanie Alvarez, case number CEBPR 2021-00021. This case is complied. And item number 63, Willie Wong, case number CEFLR 2022-00343. This case is in compliance.
And so let's follow next.
And the cases I'll be calling is item number 2 through 4, 1180 Northeast LLC. Item number 2, case number CEGMP 2022-00114. Item number 3, case number CEMIS 2022-00087. Item number 4, case number CEODS 2022-00172. And Officer General Murillo.
Good morning, Officer Murillo for the City of Miami Code Compliance. On June 24, 2022, a violation was opened for the property address on 1180 Northeast 137th Street. A violation was opened in regards to, it was asked to pressure wash and paint the entire property as needed. I had a reinspection date on July 7, 2022. There was no compliance. A notice to appear was posted for today's hearing on March 6, 2023. There was a final reinspection on March 16, 2023. And as of my final reinspection, there was no compliance.
That the property was posted during your last visit?
Yes. I'm sorry. Yes, it was posted, the notice to appear, on March 6, 2023, and it was also mailed on March 8.
Based on the unrebutted testimony of the code enforcement officer and the evidence presented, I find that the violations still exist. First time up, I find in favor of the city entering adjudication. Owners have 30 days by which to resolve the violation. If the violation is not resolved by the abatement date, which is May 18, 2023, there will be a daily fine amount of $350.
May I proceed with the next one?
Yes.
On June 24, 2022, a violation was observed on the property address 1180 Northeast 137. A violation was opened for not having pressure wash or paint the damaged awning that was asked to repair also or to remove it. I had a reinspection on July 7, 2022. There was no compliance. There was a notice to appear posted on March 6, 2023, also mailed on March 8, 2023. And as my final inspection on March 16, 2023, there was no compliance.
Based on the unrebutted testimony of the code enforcement officer and the evidence presented, I find that the violation still exists. Also find the notice and the proper notice owners that failed to appear. If I find in favor of the city entering adjudication, owners have 30 days to resolve the violation. If the violation is not resolved by the abatement date, there will be a daily fine amount of $100.
What's the fine amount?
What was the amount, Magistrate?
$150.
Next case, on also June 24, 2022, a violation on the property address 1180 Northeast 137th Street. There was a case open for items stored outdoors that needed to be removed. I had an inspection on July 7, 2022. There was no compliance. These violations were found inside the property while I was doing an inspection, which tenants gave me the permission to go in. And when I did my reinspection, I didn't have no access to the property. A notice to appear was posted on March 6, 2023. Also mailed on March 8, 2023. And I had a final inspection on March 16, 2023, which I didn't got no access to the property.
So you were not able to access the property to determine whether or not they are in compliance? No one called you out Right. What I'm going to do is I'm going to table it for another 30 days so that it can run with the other violations.
Yes.
I won't make a ruling right now. It appears to be a fix, hoping that you are in compliance. But if you're still being denied access, I will handle it at the next hearing.
Thank you.
Next case.
Next case is item number 14 through 22, which is 770 Condominium Association Inc. Case number for item number 14 is MHVIO 2022-00340. Item number 15, case number is MHVIO 2022-00341. Item number Item number 16, case number MHVIO 2022-0034350. Item number 17, case number MHVIO 2022-00352. Item number 18, case number MHVIO 2022-00353. Item number 19, case number MHVIO 2022-0054. Item number 20, case number MHVIO 2022-00355. Item number 21, case number MHVIO 2022-00356. And item number 22, case number MHVIO 2022-00359. And the officer is Jose Perez.
Feel like they are competing with Mr. Predelis.
Good morning, or almost afternoon, rather. Jose Perez, Code Manager for the City of North Miami. We're hearing the case as it relates to the property at 770 Northeast 128th Street. If I may, I'll speak to notice for all the cases at the same property because they were all notified on the same date in the same manner. The original violation was open in May 11, 2022, where it was sent via certified mail to not only the registered agent, but it was also posted at the property. Additionally, the affidavit of posting for the hearing was on March 7, 2023, and it was sent via certified mail on March 8, 2023. This would satisfy notice as to relates to the cases at 770 Northeast 128th Street. The first case is as it relates to a lighting violation. As you can see by the picture here, they pretty much have a damaged emergency hallway light that needs to be either replaced or repaired. And at this point in time, the light has not been repaired. The city is seeking an adjudication as well as a monetary fine set for the first case.
Based on the unrebutted testimony of the code enforcement officer and the evidence presented, I find that the violation also find good notice, given proper notice. Owners have failed to appear, hereby find in favor of the city, enter an adjudication. Owners have 30 days by which to resolve the violation. Violation not resolved by the abatement date of there will be a daily fine amount of $100.
Magistrate, we're getting the in and out again for some reason. I don't know if it's when you sit back, I think it does it.
Oh, okay.
Yeah.
All right, I'll get closer.
We heard the majority of the ruling, I think. Clerk, did you get all of it?
I'll just restate it so that it's clear on the record. Based on the evidence presented by the code enforcement officer, I find that the violation does exist. I also find good notice, given proper notice. The owners have failed to appear, hereby find in favor of the city, enter an adjudication. Owners have 30 days to resolve the violation. If the violation is not resolved by the abatement date, there will be a daily fine amount of $150. Madam Clerk, was that clear?
Yes, it was.
Okay. Item number 15, as it relates to a violation with missing railings on the stairwell. As of the original inspection, there was damaged railings, and as my final reinspection, unfortunately, the railings had not been repaired. As you can see, this is a potential hazard because a small child could possibly fall through that. We want to avoid that. At this time, the city is seeking adjudication as well as a monetary fine until it's resolved.
Based on the unrebutted testimony of the code enforcement officer and the evidence presented, I find that the violation does exist. Hereby find in favor of the city, enter an adjudication. Owner has 30 days within which to resolve the violation. If the violation is not resolved by the abatement date of May 18, 2023, there will be a daily fine amount due to the hazardous condition, a daily fine amount of $500 if the case is not resolved.
We'll move on to item number 16. This violation relates to the sanitation conditions in the dumpster enclosure. As you can see by these photographs, the dumpster enclosure is full of litter, debris, and it's been like that from the initial inspection. And there are some items that have never been removed, a lot of scattered debris. At this point in time, the city is requesting an adjudication as well as a monetary fine until they go ahead and clean and have a orderly dumpster enclosure.
Based on the unrebutted unrebutted testimony of the code enforcement officer in the evidence submitted, I find that the violation does exist. Also find good notice, given proper notice, owners have failed to appear, hereby find in favor of the city. Enter an adjudication, owners have 30 days. Resolve the violation. If the violation is not resolved by the abatement date, there will be a daily fine amount of $300.
Next case is number 17. This case as relates to screening. So there are several missing screens throughout the entire building. As of my final recheck, unfortunately, the screens have not been installed. At this point in time, the city is requesting an adjudication as well as a monetary fine until the screens have been installed.
Based on the unrebutted testimony of the code enforcement officer and the evidence presented, I find that the violation does exist. Also find good notice, given proper notice, owners have failed to appear. Find in favor of the city, enter an adjudication. Owners have 30 days by which to resolve the violation. If the violation is not resolved by the abatement date, there will be a daily fine amount of
I didn't hear the fine, magistrate.
$250.
Okay, we move on to number 18. This violation as it relates to the elevator, which is out of service and there's no certificate of operation. So unfortunately, as you can see by these photographs, they were actually cited by the county for having violations in the elevator as well. This is a 3-story building. To give some context, and while I was out there doing one of the inspections, I saw a very elderly lady having to carry her groceries up these stairs to the 3rd flight. And this is a problem because we have elevators for a reason. And for
do they have an active, do you know if they have an active condo association?
It is not active. Yeah, so it's a problem. It's a problem that the building is facing. For the most part, from the residents that I spoke to, they seem to be tenants. They weren't owners. Yeah. So as it relates to the elevator, it's been out of service from the moment I inspected the property to the moment I re-inspected it. And for the severity of the severeness of, my apologies, for the severity of the circumstances being with the elderly residents that have to go ahead and carry out their needs through the staircases when they could use the elevator, I feel like this one should be taken a little bit more serious. The city seeking adjudication and monetary fine until resolution is met for the elevator.
I think there's a deeper issue going on here as well. I don't know if Officer Mayer is still here, Officer Green, or even if the city attorney can chime in. So we have a condominium where no condo association, and so, you know, obviously the daily fine amount is just going to compound the problem. But when you have elderly in a building, if there's an emergency, you know, how do they get help? How do they leave the building?
We'll definitely defer this to the state magistrate as well. You know, the DVPR probably should be involved and, you know, be made aware of the situation. I don't know.
Are they aware of the situation? Because this has been going on for a year, right? In 2022?
I'm not sure if they're aware or not, but I'll definitely follow up to see. And then I don't know if the building official has any jurisdiction in a circumstance of a or safety issues.
Which
770 condominium, 11 to 30.
It's number 18 on the agenda. So they don't have an active, the elevator doesn't work over there.
Oh yeah, that's that would have to be something for Miami-Dade elevator section.
And it appears as though they went out, so it seems like they're aware of it, but we could probably follow up with them as well to see what next steps or, what they,
Okay.
Because it seems like Officer Perez says it's been out for some time. Is that correct, Officer?
That is correct.
And there's, elderly tenants. Doesn't seem like this building, this condominium apartment is being looked after or taken care of. So there's a lot of violations, a lot of issues. Obviously, my job here is limited to what's in front of me and just rule or adjudicate accordingly. I don't know necessarily that, what that's going to do. Tenants that are currently living there and having suffered all of
it could be something that could be, kind of sent to the Miami-Dade elevator section, and they can look into it further. In terms of that, the elevator, because they kind of, oversee the operations of elevators, so that's something they could take care of for that particular building.
And we can also collaborate with our attorney's office as well on the matter to see, what other additional measures can be taken as far as the city's concerned, besides the collaborations.
Okay, based on did I make my ruling yet, or?
No.
All right. Based on the unrebutted testimony of the code enforcement officer and the evidence presented, I find that the violation does exist. Also find good notice, given proper notice, owners have failed to appear, hereby find in favor of the city. Enter an adjudication. Owners have 30 days by which to resolve the violation. If the violation is not resolved by the abatement date, I find this a hazardous safety, issue. There will be a daily fine amount of $750.
We move on to number 19. Number 19, as it relates to the exterior conditions of the building needing to be pressure washed and or painted were needed. As of my initial inspection, there are several black stains and mildew stains throughout the entirety of the property, as well as just deterioration of the conditions of the actual paint itself. So at that point in time, the violation was created. They didn't correct the violation. So at this point in time, the city is requesting an adjudication as well as a monetary fine until they do.
Do we have photographs?
Yes.
Okay. Based on the unrebutted testimony of the code enforcement officer and the evidence presented, I find that the violation does exist. Again, find good notice, given proper notice, owners have failed to appear. Hereby find in favor of the city, enter an adjudication. Owners have 30 days in which to resolve the violation. Violation is not resolved by the abatement, open the fine amount of $300. Next item.
Right. As we move on to number 20, number 20 is as it relates to the miscellaneous trash and debris that are scattered throughout the entire building. We do have some photographs of these as well. Basically, there's just litter and debris scattered throughout the entire building, trash bags, miscellaneous junk everywhere, really, and it's not being properly maintained. At this point in time, the city is seeking an adjudication as well as a monetary fine until the property has been cleaned up.
Again, based on the unrebutted testimony of the court enforcement officer, the evidence presented, I find that the violation does exist. I find in favor of the city adjudication. Owners have 30 days by which to resolve the violation. If the violation is not resolved by the abatement, fine amount of $100.
You were breaking up at the end there. I'm not sure if the clerk was able to hear the fine amount.
There will be a daily fine amount of $150.
We move on to item number 22. Item number 2, as it relates to posting of the contact information for management for the association. I skipped one. Item number 21, which is a parking lot violation. There are several potholes scattered in the parking lot that need to be resurfaced or repaved. As you can see here, some of the pictures, some of these potholes are pretty bad. Nonetheless, as of my final reinspection, compliance had not been met. At this point in time, the city is seeking adjudication as well as a monetary fine until they have successfully repaired the parking lot.
Based on the unrebutted testimony of the code enforcement officer and the evidence presented, I find that the violation exists. Also find good notice. Given proper notice, owners have failed to appear. Hereby find in favor of the city, enter an adjudication. Owners have 30 days by which to resolve the violation. If the violation is not resolved by the abatement date, there will be a daily fine amount of $500.
And finally, number 22, this is for lack of contact information for management or association at the property. As of my final reinspection, no information had been posted. There are no pictures for this because obviously there's nothing to take a picture of because there's no information. At this point in time, the city is seeking an adjudication as well as monetary fine until they do post contact information.
And based on the unrebutted testimony of the code enforcement officer, I find that the violation does exist. I also find good notice. Given proper notice, the owners have failed to appear. Hereby find in favor of the city, enter an adjudication. Owners have 30 days by which to resolve the violation. The violation is not resolved by the abatement date. There will be a daily fine amount of $150.
Thank you.
I'm going to proceed with item number 33. Armando Diaz, case number CEWWC 2022-00062, and the officer is Shanna Sanders.
Shanna, are you there?
Yes, I am. We are on case 775. Okay, this is Shanna Sanders, City of North Miami Code Compliance Officer for case number CEWWC 2022-00062, property address 775 Northwest 129th Street. This violation was originally opened May 9th of 2022, whereas while doing my normal inspections, I observed 2 windows in the front of the property that had tape and boards across the front window. Had a conversation with a gentleman who identified himself as the tenant. I instructed him that the windows need to be repaired. Also instructed if they were entirely replaced, a permit needed to be obtained. As of my last reinspection, being yesterday, the windows still remain in the same condition. I am showing proper service was given. I posted a notice to appear at the property on March 6th of 2023. Certified mailing was also mailed out to the property owner. Again, on my last reinspection being yesterday, compliance has not been met and the windows remain in the same condition.
Based on the unrebutted testimony of the code enforcement officer and the evidence presented, I find that the violation does exist. Also find good notice. Given proper notice, owner has failed to appear. I hereby find in favor of the city, enter an adjudication. Owners have 30 days by which to resolve the violation. If the violation is not resolved by the abatement date, there will be a daily fine amount of $200.
Item number 35, Carlos B. Morales, Case number CEBPR 2022-00543. And the officer is Shanna Sanders.
Shanna Sanders, City of North Miami Co-Compliance Officer for case number CEBPR 2022-00543, property address 1506 Northeast 131 Road. This violation was originally observed May 18th of 2022. While doing inspections, I observed a driveway that had been installed with some pavers. I had a conversation with the property owner about this violation because I had another violation at this property referencing LDR, explaining that a driveway needed to be obtained. It was fully explained to him in detail that in addition to the other violation, that even though he was informed that a driveway needed to be installed, he was to install this one with a permit. As of today, no permit has been applied for. No, my correction, I apologize. I am showing that a permit was applied for. However, it has been in the process since 2021. Upon my last reinspection being yesterday, violation still remains. The permit application still remains pending for the driveway, but as you see in the picture, the pavers have already been installed. I am showing proper service was given. I posted the notice to appear at the property on March 9th, 2023. Certified mailing was also mailed out to the property owner by city staff. And again, as my last reinspection, an application has been submitted in 2021, but it has not been obtained.
Okay, just for clarification, so they submitted the application, and before the permit is issued, they went ahead and they put they built the driveway, correct?
That is correct.
Okay, all right. Based on the unrebutted testimony of the code enforcement officer and the evidence presented, I find that the violation does exist. Also find good notice, given proper notice. The owner has failed to appear. I hereby find in favor of the city intern adjudication. Owners have 30 days by which to resolve the violation. If the violation is not resolved by the abatement date, there will be a daily fine amount of $500.
Item number 36, Sentinelov Group LLC, case number CEBPR 2022-00513. This case was previously found guilty with an abatement date of March 16, 2023. Fine was set at $250 plus $100 cost assessment, and the officer is Jose Perez.
Good afternoon. Jose Perez, Co-Compliance Manager for the City of North Miami. Today we're hearing the case as it relates to 2095 Northeast 121 Road. This case, as mentioned, was previously found guilty, and unfortunately they have not obtained any permits for the lovely work that they've done at the property. So at this point in time, the city is asking for the fines to be ratified as it relates to the glass barrier that they installed on the seawall. I'm sorry, notice. I missed saying notice. I should have said that. The property was posted for the hearing on March 7, 2023, and was sent via certified mail on March 8, 2023, and that would have been notice.
Based on the unrebutted testimony of the code enforcement officer, I find that the violations still exist. Daily fine amount of $250 is hereby ratified.
Thank you.
Item number 38, Country House Bar Rosa LLC, case number CEFOB 2022-00325, and the officer is General Murillo.
Good afternoon, City of North Miami. Officer Murillo, City of North Miami Co-Compliance. On May 5th, I opened violation to the property address 12955 Biscayne Boulevard, Unit 328 for Marina Title LLC. for not applying or obtaining a business site receipt for the city of North Miami. I had an inspection on June 6, 2022. There was no compliance. A notice to appear was posted on March 6, 2023. It was also mailed on March 8, 2023. As my final inspection on March 16, 2023, there was no license on file.
Based on the unrebutted testimony of the court enforcement officer and the evidence presented, I find that the violation does exist. Also find good notice. Given proper notice, owners have failed to appear. And thereby find in favor of the city enter an adjudication. Owners have 30 days by which to resolve the violation. If the violation is not resolved by the abatement date, there will be a daily fine amount of $250.
Item number 39, Eddie Ronville, case number CEPFY 2022-00177. The officer is Janelle Murillo.
Good afternoon, Officer Murillo for the City of Miami Code Compliance. On May 14, 2022, a violation was opened to the property address 1121 Northeast 135th Street. In reference to parking vehicles in the front lawn, I had a reinspection on May 25th, 2022. There was no compliance. A notice to appear was posted on March 6, 2023. It was also mailed on March 8, 2023. I had a final reinspection on March 16, 2023, and there was no compliance.
Based on the unrebutted testimony of the court enforcement officer and the evidence presented, I find that the violation does exist. I also find good notice. Given proper notice, owners have failed to appear. Hereby find in favor of the city enter an adjudication. Owner has 30 days by which to resolve the violation. If the violation is not resolved by there will be a fine.
We're in and out again. Is the fine $150?
Yes.
Item number 42, HGMC Building Build LLC, case number MHVIO 2022-00701. This case was previously found guilty with an abatement date of March 16, 2023. Fine was set at $300 plus $100 cost assessment, and the officer is Gennaro Murillo.
This is item 42. Good afternoon, Officer Murillo, City of Miami Code Compliance. This case is being heard for the second time. My case was opened on November 9, 2022 for the property address 665 Northeast 133rd Street. They were advised to exterminate the Unit 16 and provide an extermination report. A notice to appear for today's hearing was posted. I'm sorry, there was no compliance. And a notice to appear was posted on March 6, 2023. Also mailed March 8, 2023. And a semi-final inspection on March 17, 2023. There was no compliance. They haven't been in contact with me. And also Mr. Charles Brown, the tenant, also advised that they haven't been in compliance or haven't been in contact with him.
All right. Based on the unrebutted testimony of the court enforcement officer, I find that the violation still exists. The daily fine amount of $300 is hereby.
Item number 43, Mauricio Duauer. Case number CETRE 2022-00021, and the officer is Shanna Sanders.
Shanna Sanders, City of North Miami Code Compliance Officer. This is a new case for tree removal. I originally started the property on October 26, 2022, whereas I received a call stating that an individual was cutting trees. At the time of inspection, there was somewhat of a language barrier, so I called my colleague and asked for translation. Through translation, we were issued, the property owner, a courtesy notice and was given a week to come in and submit an application to the city, requesting, a tree removal permit. Upon my reinspection on November 8th, no permit application has been submitted to the city, nor did he contact the community planning and development office about any tree removals. So I moved forward with issuing a notice of violation. I have not had any contact with the property owner or any listing agents from the property since my initial deliverance of the courtesy notice on October 26th. Upon my reinspection on March 16th, I went back to visit the property yesterday just to verify if anything had changed or taken place. No compliance has been met. I have reached out to our third-party contract company to inquire had an application been submitted. An application has not been submitted as of yesterday. I am showing proper service was given. A certified mailing was mailed out to the property owner on March 9th, whereas I posted the property as well as notice was sent out certified mailing.
Based on the unrebutted testimony of the code enforcement officer and the evidence presented, I find that the violation does exist. Also find good notice, given proper notice, owners have failed to appear. I hereby find in favor of the city, enter an adjudication. Owners have 30 days by which to resolve the violation. The violation is not resolved by the abatement date. There will be a daily fine amount, $400.
Item number 44, Jean Gulbatin, case number CEBPR 2022-00537. The officer is Janelle Murillo. Oh, sorry, we have two cases, 44 and 45. And the other item number 88.
Did you mute it or something? Did you read the second case?
Yes.
You're breaking it again because we didn't hear you.
Sure. Item number 44, case number CEBPR 2022-00537. And item number 45, case number CEGMP 2022-00088. And the officer, Janelle Murillo.
Good afternoon, City of Miami. Code Compliance Officer Murillo. On May 12th, I opened a violation to the property address 1040 Northeast 146th Street. Our case was open for stucco work that was done on the back of the property. I had an inspection on May 31st, 2022. There was no compliance. A notice to appear was posted for today's hearing on March 7, 2023, which there was also more stucco work done on the property with no permit. The notice to appear was also mailed on March 8, 2023. On March 16, 2023, I had a final inspection. There was no application submitted.
Can you give your notice?
I'm sorry?
Can you advise when notice was given and posted?
Yes, the notice to appear was posted on March 7, 2023, and it was also mailed on March 8, 2023. May I proceed with item 45?
Absolutely.
Also, a case was opened on May 12th. So the property address 1040 Northeast 146th Street. There was asked to pressure wash and paint the walls on the back of the property. I had an inspection on May 28, 2022. There was no compliance. A notice to appear was posted on March 7, 2023. It was also mailed on March 8, 2023. I had a final inspection on March 16, 2023, and there was no compliance.
First time up. All right, based on the unrebutted testimony of the code enforcement officer and the evidence presented, I find that the violation does exist. I also find good notice, given proper notice, owner has failed to appear. Hereby find in favor of the city entering adjudication. The owners have 30 days by which to resolve the violation. If the violation is not resolved by the abatement date on case number CER 2022-00537, there will be a daily fine amount of $350. Case number CEGMP 2022-00088, there will be a daily fine amount of $500.
I'll proceed with item number 48. Louis A. Sinsahoha, case number CEBPR 2022-00546, and the officer is Gennaro Murillo.
Good afternoon. On May 19, 2023, I follow up on a complaint. A violation was found and open on May 24, 2022 on the property address 14045 Northeast 7th Avenue for not having a permit for the newly built metal and chain link fence on the property. I had an inspection on June 9, 2023. There was no compliance. On March 7, 2023, a notice to appear was posted for today's hearing. On March 8, 2023, it was also mailed. I had a final inspection on March 16, 2023. There was no compliance.
Thank you. Based on the unrebutted testimony of the code enforcement officer, evidence presented, I find that the violation does exist. Also find good notice, given proper notice, owners have failed to appear. I hereby find in favor of the city entering adjudication. Owners have 30 days by which to resolve the violation. If the violation is not resolved within 30 days, there will be a daily fine amount of $250.
Item number 49, NMB Partners, LLC, case number CEDCU 2022-00406. This case was previously found guilty with an abatement date of March 16, 2023, fine set at $250 and the plus $100 cost assessment, and the officer is Christopher Olson.
Good afternoon. This is a previously heard case. Violation was issued 4/15/2022. We gave them extension on this case before on 2/7/2023. Also, they were found guilty. And as of the final reinspection on 3/17/2023, the violation still remains. The property was properly noticed and posted and mailed out.
Based on the unrebutted testimony of the code enforcement officer, I find that the violation still exists. Also find good notice, given proper notice, owners have failed to appear. The daily fine amount of $250 is ratified.
Thank you.
We'll proceed with item number 50, North Miami Storage, LLC. Case number CEDCU 2022-00459. This case was previously found guilty with an abatement date of March 16, 2023. Fine was set at $250 plus $100 cost assessment. And the officer is Gennaro Murillo.
Good afternoon, Officer Murillo for the City of North Miami Code Compliance. On April 25th, 2022, a violation was opened to the property address 640 Northwest 133rd Street. In regards to not obtaining a certificate of use. I had an inspection on May 31st, 2022. There was no compliance. It was previously heard on a magistrate hearing on January 26, 2022. On March 7, 2023, a notice to appear was handed to Mr. Robert. It was also mailed on March 8, 2023, as my final inspection on March 16, 2023. No compliance has been done.
Based on the unrebutted testimony of the code enforcement officer, I find that the violation still exists. I also find good notice, given proper notice, owners have failed to appear. The $250 daily fine is hereby ratified.
Number 53, Robert A. Foncree and wife Karina. Case number CEDSP 20220008. And the officer is Shannon Sanders.
Shannon Sanders, City of North Miami Code Compliance Officer. This is a new case. It was originally cited May 12, 2022, whereas I was doing my normal inspections, observed a property that I had inspected before that had, several violations open. Long story short, I opened it for a depreciation of surrounding properties. It looks to be in deplorable conditions. I had a conversation with the tenant, if not occupant, who instructed she would clean the property up, cut back some of the trees, repair the fence, things of that nature. But as of my last reinspection, it has been a little work done, but the property still looks deplorable and still brings down the property values of the surrounding neighboring residents and business owners. I am showing proper service was given. I posted the property with the notice to appear on March 10th, 2023. Certified mailing was also mailed out to the property owner regarding the violation. I would like to move forward with requesting this violation be adjudicated under the depreciation of surrounding property violation.
In this case, was been over almost a year ago.
I'm showing here I originally opened it March 12th of 2022. Yes.
In a year. Okay.
Yes.
All right. Based on the unrebutted testimony of the code enforcement officer, I find that the violation does exist. Also find good notice, given proper notice, owners have failed here. I hereby find in favor of the city entering into vacation. Owners have 30 days by which to resolve the violation. If the violation is not resolved by the vacation date, there will be a daily fine amount of $500.
I'm going to proceed with item number 55 and 56. So Justine Thorlings, case number for item number 55 is CEDPR 2022-00542. And item number 56, case number is CEDTU 2022-00102. And the officer is Shannon Sanders.
Shannon Sanders, City of North Miami Code Compliance Officer. The first case is for building without permits, CEDPR 2022-00542. I initially opened this violation on May 16th of 2022. I received a call from a resident stating a structure had been built in the rear of the property, whereas they were having church services. Upon inspecting the property, I had a conversation with a gentleman who identified himself as the property owner, as well as the pastor of the church. I explained to him that structure in the rear of the property needed to be either permitted in or removed. We had a long, detailed conversation that didn't go too well. He stated it was his property. He can more so do what he wanted to do. I have not had any further conversations with the property owner as of my last reinspection being March 16th, as well as yesterday. The structure still remains in the rear of the property. No permits have been obtained for the structure. I am showing proper service was given. I'm showing that the notice to appear was posted on the property on March 10th of 2023. Certified mailing was also mailed out at the property on the 12th of March. Again, as of my last reinspection, the structure still remains and no permits have been submitted to the city to bring that structure into compliance.
Can you bring that photograph up again? Because I thought I saw, this is a full structure blocking the windows and everything, huh?
Yes. Yes, it is.
It went through the whole trouble building this and without permit and just blocking the windows in the process.
That is correct.
And you said you made contact with the owner, with the property owner?
Yes, when I went to post the notice on the door, of course, the property owner came outside. First, it was his wife, and then the gentleman stepped out. He identified himself again as the property owner as well as the pastor of a church. He did, as the conversation went on, he stated with COVID and everything going on, he had to close down his church. So he was careful in stating he was having service, but not having service. He only had a few people there. He was just playing a little music. They were just gathering, sharing the word. But yes, we had a conversation about the structure and the service, which is the next violation. But again, he stated it was his property. He can do what he wanted to do. Go ahead and move forward with presenting the cases. I'll speak my piece at the hearings. He spoke of knowing several people at the city, but again, as of today, he's not here, and I would like to move forward with adjudicating this violation.
I saw. Yes. Based on the unrebutted testimony of the code enforcement officer and evidence presented, I find that the violation does exist. Also, good notice. Given proper notice, owners have failed to appear. You did not mention whether or not it was any safety issues as it relates to the structure of
I'm sorry, you were cutting up. Are you asking me a question?
I did, and I apologize. I'm not sure what's going on with the mic. I said you did not indicate whether or not there were any safety hazard as it relates to the actual structure. I mean, it looks a little sideways, cockeyed, but
I'm not a building inspector, but from the looks of it, like you say, it was leaning. It doesn't look like something that the city would even permit. So, I will consider it unsafe from just the visible eye. It wasn't set up to be, it didn't appear to be a structurally sound structure.
Yeah, I'm a tad bit concerned too, because I know I see there's a second case, and you said it's probably being used, but I'll wait to hear the testimony. So that is of concern. And the fact that you indicated that you had direct conversations with them and they didn't even bother to appear today. So I do find the violation exists. I will give 30 days. Property owners have 30 days within which to resolve the violation. If the violation is not resolved within 30 days, there will be a daily fine amount of $750. I'm just trying to send a message that this is serious stuff, and we don't want to create a situation where people are putting in hazardous situations.
Moving forward with the next case, in conjunction with the past one, originally cited again on March 16th of 2022, whereas I received a phone call about services taking place at the residence in the rear property of a resident, whereas they had a makeshift structure. Upon me posting a notice on the door, the property owner, who identified himself as a pastor as well, had a conversation with me. As he stated, he has a few people gathering at the property. He considers it sharing the word. They play a little music, things of that nature. Again, he was very careful as to say, once I asked or inquired about service being, held, he states, again, he doesn't have service. He just has a few people from his church that he had to close due to COVID taking place and, financial situations going on. I have not received any further complaints about any services going on. I have not had any further conversations with the property owner past that date. I re-inspected the property. The structure is there, but I'll be honest enough to say I reached out to the individual who made the complaint. As usual, they don't want to get involved. So I was kind of hesitant with bringing this case, but I wanted to bring it, just in case, again, by the pastor's omission, he was having gatherings, playing music, sharing the word with some of his past parishioners. So, I'll leave it up to you to.
I would say, magistrate, in this circumstance, provided that the structure is still there, that the cases run together in terms of zone prohibited use, as we're not able to confirm. I think that, if the property owner would engage the city and provide for an inspection, indicating that the use is, or that the structure is removed, that would imply that the use has been eliminated.
And for what it's worth, sorry.
I'm sorry.
I wanted to just bring up section 1117, where it says that churches are exempt from having to obtain a BTR, for example. To whatever extent this is, worth bringing up, but I wanted to just let you know.
Well, I didn't cite it so much under a business tax receipt violation. I did it under a zone prohibited use. This is a single family resident home that, erected in a structure in the rear that's holding service. So again, it was cited under a zone prohibited use violation.
My only issue is that it's not confirmed whether or not it is being used. We're assuming, based on the owner's own statement to the officer, that he's using it as a gathering place for himself and his old former members. So that's an issue in of itself. But I think that, the hefty fine in the first case, and I'll give you a minute, Mr. Jean, to chime in. It should, put enough fire under their feet to get this matter, to get things moving. But you said that you sent them a cease and desist letter. I don't know if that came from the you're shaking your head, Crystal.
No, it was just noted in the notice that was sent out, but no formal cease and desist was sent to the property.
I'm wondering if this is a situation where until we're... Go ahead, Mr. Dean. What did you want to add?
With that, I can... I don't know if I could... if I have to enter the yard to view it, if it's basically private property.
Based from the photograph that was shown, does it seem like it's you can see it from the front, right? It seems like you can see it from the street. No,
it's in the rear of the property, but it's right along 125th Street, so you can visibly see it from the side. If you're standing on 125th, you can see it clearly. That's where I took that photo from.
And the other thing that I wanted to just throw in there as my wheels are spinning is that, bearing in mind, this is a residential zoning district. So in theory, I mean, regardless of whether it would be a church or whatever is happening in there, the zoning is residential, single family. So, we can't necessarily, it's a whole structure. It could be someone living in there. There could be, it could be an additional unit. The city just doesn't know. But what we do know is that it hasn't been approved by the city. And so as such, essentially it could be, there could be a kitchen in there. There could be, we just don't know. So I think that we still have, regardless of whatever the use is, I think that, just based on the zoning that the city has designated for this particular area of the city, it's single family. And I wouldn't see where this structure would meet that requirement, seeing as it's been erected in the rear of the single family.
I'm waiting on you, Mr. Jean.
Okay. No, I mean, so it seems like it has some a zoning issue from the get go. So either they obtain a permit, but there may be some setback issues and that they can't comply with, or some type of variance they need to go through. So they would need to go through the process for the permitting. Definitely for permitting. And if it's something that's unsafe, that I guess I would have to just try to view it from the street to see if it's something in danger of being either collapsing or something.
Yeah, because I'm gonna put the picture again. It's almost not even like level.
Oh no! Yeah, no, it's no.
Yeah, I mean, this little area here seems like
it's lopsided. It's leaning.
Yeah. And it's even worse. It's even worse when I looked at it yesterday. It's leaning even more. I wish the photos was uploaded.
It's blocking their windows,
which could be a hazard. Almost be attached to the property. You can see here. They have a door, so I would assume that there is probably a bathroom or maybe an air condition or something else going on in there. The roof is not, whatever this is, doesn't appear to be intact.
It's like a tent structure. It's almost like
basically another unit now that's been attached to the property. So, ruling out even the conversation around a church, it's just an additional structure that's been erected and outside of the single family use, I think for sure,
it won't be approved. It's best, yeah. What's that number? What's the case number? So that way I can.
We just 55 and 56. And what is the city asking on item number 56? Maybe that's what I'm not clear on.
I would ask for it to be adjudicated. It could run, coincide with 55 as well. Whatever the reinspection date was that, we'll leave the burden on the property owner to allow us into the property to see what's going on inside the structure and to obtain the permit. So again, I'm asking for an adjudication.
All right. Based on the unrebutted testimony of the code enforcement officer and the evidence presented, I find that the violation does exist. Also find good notice, given proper notice, owners have failed to appear, hereby find in favor of the city. Intern adjudication, owners have 30 days by which to resolve the violation. If the violation is not resolved by the abatement date, there will be a daily fine amount of $700.
Does that conclude the agenda, clerk?
We have item number 57, Salem House Holdings LLC, case number MHDL 2022-00195, and the officer is Jonathan Lemestre.
Good afternoon, everyone. Co-Compliance Officer Jonathan Lemestre, and this case is being heard for the first time. On February 24th, 2022, I conducted an annual housing inspection at 13155 Northeast 6th Avenue. This is in regard to the glass doors being damaged throughout the property. There's 34 units at the property, and I want to say at least half of the glass doors are damaged at the property. On February 25th, I posted the notice of violation, and I also mailed the registered agent and the property and the mailing address on Property Appraiser. On March 8th, 2023, I posted the order to appear for the magistrate for this magistrate hearing. March 9th, 2023, I mailed the order to appear to the property owner. And on March 16th, 2023, when I did the final reinspection, compliance hasn't been met. So in the photos, you can see that the glass doors, they're either broken, damaged, missing. And yeah.
This is an apartment building? I'm sorry.
This is a multifamily, 34 units in total.
Based on the unrebutted testimony of the code enforcement officer and the evidence presented, I find that the violation does exist. I also find good notice, given proper notice, owners have failed to appear. Hereby find in favor of the city entering adjudication. Property owners have 30 days by which to resolve the violation. If the violation is not resolved by the abatement date, there will be a daily fine amount of $500.
Thank you.
Item number 58, SoFlo Investments Group LLC, case number CEDSP 2022-00006, and the officers Janice Sanders.
Shanna Sanders, City of North Miami Code Compliance Officer. This is a new case. This case was originally cited April 25th of 2022. While doing my normal inspections, I observed a property that, looked to be an eyesore. It had been having construction going on from what I have observed and from looking at prior violations for, a little over 2 or 3 years now. I had a conversation with a woman who identified herself as the property manager. She stated that she would put a fence around the property when we were having hearing some of the other violations that had taken place. A gentleman identified himself as having some type of association with the property. Again, they stated they would put a fence around the property because there is structured construction that has started and stopped over the past 3 years. Grass that has grown is unleveled. It's just, an eyesore for the neighboring properties. As of my last reinspection being yesterday, the property still remains in need of being construction needs to be finished. A fence needs to be.
Can you pull item number 58, please?
While she's pulling up the pictures, I'm gonna make sure to say that posting was posted at the property March 10th of 2023. And certified mailing was mailed out on the 12th. As you see here,
is it abandoned because it's boarded up?
It's vacant. I would say a vacant. I won't say so much as abandoned because they have stopped and started construction throughout the years. From what I recall through prior, looking at, prior violations, I believe there was a fire or something that took place. They obtained permits, they expired, they renewed them. For the past year or so, construction has stopped and it's been boarded up like this. We have asked them, even at some of the last hearings when we were hearing prior cases, to at least fence it off so it's not so much an eyesore. But, as of my last re-inspections, the property still remains open and exposed. Grass is unleveled, is unsafe, and just doesn't look to be aesthetically nice in a residential area.
Okay. Based on the unrebutted testimony of the code enforcement officer and the evidence presented, I find that the violation does exist. Also find good notice, given proper notice, owners have failed to appear. I hereby find in favor of the city enter an adjudication. Owners have 30 days by which to resolve the violation. If the violation is not resolved by the abatement date, there will be a daily fine amount of $500.
Magistrate, that concludes all the items from today's agenda.
Wonderful. So that we are adjourned. Thanks, everyone.
Thank you.
Thank you. Have a good one.
Bye.
Recording stopped.